Pursuant to your lordship's order, the amount has been deposited before the family court. But family court is not releasing unless an order is passed from this court. I have filed an IA.
I will pardon, my lord. One CRL is there in my lordship's board. That is CRL number 314 of 2013, item number 55. In that case, my lord, the father of the appellant died on 21/8/2023, my lord. I have given a copy of the IA to my learned friend, along with that the declaration given by Sarpanch as well as the application of under Harishchandra. Lordship may kindly.
Where is that, ma'am? IA.
That I have given, and that I also have filed on case.
My lord, I may be pardoned to make a mention, your lordship. Item number 62 of the hearing list, your lordship. The criminal appeal related to 2015, your lordship. My lord, on the previous week, your lordship, I made a mention, and my lord has directed me to come with the vigilance counsel, who has been interested to that case. And your lordship, I assured that my esteemed sister is in the vigilance side, and my lord, it will take only 20 minutes.
There are 3 part-heard matters, so once it is over, I can take it out. So you have to wait.
It is actually ruling. It was earlier in this item number 8.
Once it becomes part-heard, it will come to the top. So for that, you have to wait till the other 3 part-heard matters are over. Okay.
77 also the vigilance matter, my lord. A hearing matter, my lord.
You wait. Yes.
My lord, CRLA number 259 of 2010. It was heard by Honorable Mr. Justice Raut Rai on 27th April 2022, and CBI had to complete its argument on 29th June 22. Because of change of assignment, that matter is now before your lordship. And on my mention, your lordship had directed on 16th March 2023 to put up this matter on 6th April. But due to heavy rush of bail applications before the summer vacation, no CRL was listed, and your lordship had directed to mention.
You will see that. Yes, sir.
May I mention a matter not in my lord's board?
Yes, Mr.
My lord, may I mention a matter not in board, my lord? The matter coming that to be mentioned matter coming tomorrow, and I have another matter before my lord. In item number, my learned friend will give the numbers. I'll be deeply obliged if my lord can take it up at 2 o'clock, because I'm stuck in the Supreme Court in the first hour, my lord.
That election petition is posted to today, tomorrow. So that will start at 11 o'clock. So I cannot. It will be listed. We'll see that tomorrow. I'll first let it be listed, and we'll see if it is possible. We can
anytime. Okay. That's already. Well, I'll not be able to mention. Therefore, I mentioned tomorrow. I will not be able to mention.
Yes.
Lordship, pardon to make a mention, Lordship.
Yeah.
Lordship, on criminal appeal 900 of 2023, the appellant has been convicted for 3 years, Lordship.
Yeah. What do you want?
Lordship, the matter is not listed. That's why.
No, it has not been admitted.
No, your Lordship.
Oh, fresh matter. What is the number?
Criminal appeal number 900 of 2023.
All right, it will come on Monday.
Yes, sir.
Yeah. No, the moment that interim application comes,
Weekly list item number 1.
Please, because this is a part-heard matter, I'll just recapture the facts for my lordships. There are 2 appellants before my lordships in CRA number 20 of 2001 and CRA number 21 of 2001. My lordship remembers is there 2 persons before my lordship, and the allegation was that one of the appellants, that is Narendra Sethi, had procured rice on behalf of 4 other persons, total 5 including himself, to the extent
you have been found The charge is read out that charge first.
Would the accused person stand charged under Section 7 of the Essential Commodities?
No, you come to the charge frame, but that page 36.
The day of September 99 at about 1 p.m. at Bisoi Market Building, room number 7, have misappropriated 100 kg of BPL rice in contravention of Clause 3.1 of the EC Act and Clause 8 of the Odisha Rice and Paddy Control Order 1965.
So it's a 7 EC Act.
Conviction is under 7 EC Act.
Okay, the Odisha Rice Paddy Control Order.
That is quoted in the judgment matter.
No,
Page 27.
Let me see that book.
Of the judgment.
Page 23.
Odisha Rice and Paddy
Para 8.
Control Order 1965. 153 page.
Para 8, my lord.
So the contravention is clause 8. Let us see clause 8. No holder or a license issued under this order or his agent or servant or any other person acting on his behalf shall contravene any of the terms and condition of the license. And if such holder or his agent or servant or any other person acting on his behalf contravenes any of the said terms and conditions, then without prejudice to any other action that may be taken against him, his license may be suspended and cancelled by order in writing of the licensing authority, provided an order shall be made on this condition.
That is with respect to one of the appellants who was acting as the distributor, Lordship. But in the present case, it is admitted that the license of the said dealer, alleged dealer, is not proved, not seized by the prosecution.
For section 106 of the Evidence Act, my lord, the special knowledge, proving of special knowledge, that is to be, that lies, burden of proving lies on the defense to prove.
No,
the appellant has not proved his the fact that he had got license to procure rice from the store agent and to distribute the same to the beneficiaries, my lord. 106 is very clear, my lord. 106 of the Evidence Act.
No,
I'll submit.
The to attract this offense under 7 EC Act, which has been framed for that they have violated the clause 8 of the Orissa Rice and Paddy Control Act. Another is clause 3.
Section 3, subsection 1, my lord.
3.1 is.
And section 3 is quoted in judgment. Your lordship may kindly see page 23, para 8, my lord. The section is quoted. It says that is clause 3, subsection 1 of EC Act.
The central government is of the opinion that it is necessary or expedient so to do for maintaining or increasing supplies of any essential commodities or securing the equitable distribution and availability at fair prices or for securing essential commodities for defense of India and so on. So it may by order provide for regulating or prohibiting the boundary. So suppose somebody is having the license and he flouts the terms and condition of the license which has been issued. So then can only he will be prosecuted and punished under Section 7 of the EC Act. So here
this appellant had no license to procure rice from the storage area and distribute to the beneficiary.
It speaks about the dealer's license, Your Lordship, not the beneficiary's license. There is no license as such as the beneficiary should have. The beneficiary should only have its BPL or APL card, on which the record of rice taken in each month is registered and countersigned by the distributor. The license that the Act speaks of is only with regards to the distributor or the supplier of the rice, or the authority on behalf of the government who is supplying the rice. In the present case, it is Sri Manoj Kumar Mahanti, the appellant.
There are two appellants here.
Lordship.
One is Manu, and for both of them you are appearing.
My lord.
So what is the allegation against Narendra and what is the allegation against
My lords, I'll just encapsulate the facts, Lordship. What had happened was Shri Manoj Kumar Mahanti was given the duty to distribute rice in that Bisoi market on behalf of the government, BPL and APL rice. Shri Narendra Sethi, along with his card, had possession of 4 other cards of 4 other different villages. Fact admitted is that their village is 15 kilometers away from Bisoi Gram Panchayat, and he had come to procure rice on behalf of those 4 persons. When he had collected rice from Manoj Kumar Mahanti of about 1 quintal, that is 100 kgs, 20 kgs for himself, 80 kgs for 4 other persons, Manoj Kumar Mahanti signed on all those 4 BPL cards and he had entered the same in his register. After that, when he was tying up the entire 100 kgs in one bag, gunny bag, and loading it on his cycle, the surrounding villagers nearby doubted that this particular person is illegally transporting rice or taking it for his own consumption or for selling or for other reasons. They detained him. After they detained him, they called the marketing inspector. The marketing inspector arrived, seized the rice, seized the BPL cards from Narendra Sethi and the register from Manoj Kumar Mahanti. Manoj Kumar Mahanti, being the distributor, is under an obligation to maintain a register of supply of rice, and seized all these items, and then they came up with the prosecution case. This is the gist. This is the actual gist of how it happened. What I'm not denying, Your Lordship, is the possession of 100 kgs of rice. But what I'm claiming is that I was procuring it on behalf of 4 other villages.
Wait.
Lordship.
You come to the page 38.
38, my lord.
The accused statement, question number 4.
Admitted, my lord.
That the accused statement of Manoj Kumar Mahanti. It starts from page
38.
In accused
37.
statement, both the appellants have admitted that.
Wait. 38 ko asandu.
Question number 4, my lord. May I please?
Yes, sir.
PW3 Chandra Mahakut says that you are the GP Secretary of Bisoi and authorized to sell APL and BPL rice. On 1/9/99, he had been to your sales center to bring rice along with other villagers at ₹2 per kg and found that accused Narendra Sethi took rice in 4 consumer carts, and he and others told you why you had given 1 quintal of rice to accused Narendra in 4 carts, and they detained 1 quintal of rice from the possession of accused Narendra Sethi and informed to the marketing inspector Bisoi block, who seized the same in his presence. What have you got to say?
What is the answer? 5 ଜଣ ଲୋକଙ୍କ BPL କାର୍ଡରେ ମୁଦାଲା ନରେନ୍ଦ୍ର ମୋ ଠାରୁ 1 କ୍ୱିଣ୍ଟାଲ ଚାଉଳ ନେଲା। ଏଇ ହଉଛି ଆପଣଙ୍କର ତାଙ୍କର ପ୍ଲି, ମାନେ ସେଇ ଯୋଉ ଲୋକଟା ଯିଏକି ସେକ୍ରେଟାରୀ
ମନୋଜ କୁମାର ମହାନ୍ତି,
ମନୋଜ କୁମାର ର ପ୍ଲି ହଉଛି ଯେ 5 ଜଣ ଲୋକଙ୍କର BPL କାର୍ଡ ସେ ଆଣିଥିଲା, ଆଉ ଏ 5 ଜଣଙ୍କ ପାଇଁ ସେ ନେଇକିନି ଗଲା। So that is your plea. Now you come to the other person, that means the other accused, and see his statement.
Page 40.
No, that particular question has also been put to him. Question number 4. And read it out again. See that.
PW3 Chandra Mahakut says that on 1/9/99, he had been to the sales center of APL and BPL rice to bring rice along with other villagers at ₹2 per kg and found that you took 1 quintal of rice in 4 consumer carts, and they told you why you had taken 1 quintal of rice from your co-accused Manoj Mahanti, and they detained you, rice and the cycle which PW2 seized at the spot, and police arrested you, being produced by PW2 and others. What do you have to say? Mudala Manoj ଠାରୁ 1 କ୍ୱିଣ୍ଟାଲ ଚାଉଳ ଆଣିଥିଲି।
ତାହେଲେ କଣ, ମାନେ ଏ ଦିଟା ଯାକ ଷ୍ଟେଟମେଣ୍ଟ ଯଦି ହେଲା, ତାହେଲେ କଣ ଜଣେ କହୁଛି ହଁ ଇଏ ଆଣିଲା, 5ଟା କାର୍ଡ ପ୍ରୋଡ୍ୟୁସ କଲା, ଇଏ ନେଇକିନି ଗଲା 1 କ୍ୱିଣ୍ଟାଲ। ସିଏ ମଧ୍ୟ କହୁଛି ହଁ ମୁଁ 5ଟା କାର୍ଡ ଆଣିଲି, 5ଟା କାର୍ଡ ନେଇକିନି 5ଟା କାର୍ଡର ରାଇସ୍ ଅର୍ଥାତ୍ 20 କିଲୋ ନେଇକିନି ମୁଁ ଯାଉଥିଲି। Admitted ତ? Come to your defense plea. That defense witness, DW1, page 58.
May I read?
Yes.
I know the accused persons. I know Marketing Inspector Sapneshwar Mishra. I am the ward member of Bisoi Gram Panchayat. I am taking rice in my BPL card from Panchayat. My village is at a distance of 15 kilometers from Bisoi. There is no road communication from my village to Bisoi. On 1/9/99, I had been
That is
to...
the date of occurrence.
Yes.
Read slowly.
On 1/9/99, I had been to Bisoi to bring my BPL rice from the Panchayat. Narendra Sethi, Shiba Sethi, Subhasini Sethi, Rabi Sethi,
card holders.
And Narayan had come with me to Bisoi to take BPL rice. Then we all kept all the rice in one bag and I stitched the bag. Then I loaded the bag in the cycle of Narendra Sethi. At that time, we all, the BPL consumer card holders, were present. In the meantime, the marketing inspector came and detained the bag.
So, what is the defense case? That all those 5 persons came, including this co-accused Narendra Sethi, whose criminal appeal is 21.
Lordship.
And they all received their individual rice.
Lordship.
Okay, it's not that Narendra received the rice on their behalf, as per the accused statement. So they individually came they received their rice. Then it was packed in one bag, and Narendra was asked to carry the same. So is it not the plea which has been taken by you in the defense plea and the plea of the accused persons in their accused statement? Is it not discrepant? You are telling in your accused statement that those four persons entrusted you to bring their card, and you receive the rice on their behalf from this Manoj, and then you were carrying the 1 quintal. But your witness says that no. All the 5 came, including Narendra, and they received their individual rices. That was packed in one bag, and that was being carried by the Narendra. So if that is your plea, that means 5 persons had come, they received their individual rices. Then whose signature would be there in the stock khata? That purchase signature of each of the person. Now you come to see that what signatures are available there. Kaha signature seti thila. Gotekar total signature hi nathila. You just placed the matter on that day also. Okay. Somebody's signature was totally not there, and for other persons that signature was there. This man's Narendra's signature was there. You that will find you at page. I'll state. You come to page 47, examination of PW2 on recall. Got it? Paragraph 5, third line. Thereafter, Thereafter, yes, read it. Thereafter, I checked the sales center, and accused gave an endorsement that he was carrying 1 quintal of rice in 4 BPL and 1 APL cards. Exhibit 4 is the endorsement with signature of the accused on the public petition by accused Narendra Sethi with objection. On my inquiry, I found Manoj Mohanty had given 1 quintal of rice in 4 BPL and 1 APL cards to accused Narendra Sethi, and accused Manoj Mohanty had entered this in his sale register. Why APL card? Just stop for a moment. So what he found, if after verification of that sale register, that all the rice was received by only one accused. Okay. So that is he had brought 4 BPL and 1 APL card, and it is he, that means Narendra Sethi had received it, and Mohanty had entered this in the sale register. जे माने आंकु ए नरेंद्र सेठी को ए 5 जनक पई दिया हला, इंक्लूडिंग नरेंद्र सेठी मध्य कार्ड थिला, बट ए 5 जन पई दिया हला जन. Then you read the next line. And why entered this in his sale register? Why APL card number such and such in the name of Gangadhar Sethi? Accused Manoj had not entered in the sale APL card regarding issue of rice, but he has entered the said issue of rice in the sale register. तो दीटा जगह एंट्री हवा कथा आगे जने जेतले मो कार्ड रे नहीं की जाउची जदि मु निजे जाए बा आउ का हाथ रे मोर मगाए मु जाई परलिनी कोनोसी असुविधा जोगु अन्य हाथ रे मु कार्डटा देकिनी पठेइली से आनिबा पई ताले जने जेतबेले डिस्ट्रीब्यूटर अछि सी सेतबेले दीटा जगह एंट्री करिवो ता निज रजिस्टर एंट्री करिवो मु 20 केजी बिकिली बेली हला कारण तार स्टॉक रो पुनी पोजीशन जणा पड़िवो तो सेतरु एवं जहा को दिया हला ता धेरे भी तार रेशन कार्ड रे एंट्री करिवो नचे सी क्लेम करिवो जे ए मास रे मते 20 किलो दिया हिनी हला तो दीटा जगह एंट्री हवा नियाती दरकार. तो एठी कोन हला ना जोटा एपीएल कार्ड रे एंट्री हेई नाही केवल एंट्री हेची कोठी ना रजिस्टर एंट्री हेची. तेणु कम टू द नेक्स्ट लाइन. But he has entered the said issue of rice in the sale register.
Sale register.
हाँ,
Exhibit 5 is the
APL card.
card.
He has not entered.
in
This
the-
is most important.
Okay.
He has not entered in the above APL card, but has entered in the sale register on 7/7/1999
about sale.
About the sale of rice. Exhibit 6/1 is the entry relating to the issue of rice to Narendra Sethi. 6/2 is my signature, so and so. I had verified the register. On 1/9/1999, I had verified the sale register and found that 20 kg of rice was issued in the name of. This is the date of occurrence.
Gotcha.
Padhantu.
On 1/9/99, I had also verified the sale register and found 20 kgs of rice was issued in the name of Gangadhar Sethi, but it had not been mentioned in his APL card. Exhibit 7/1. Exhibit 7 is the said register. Exhibit 7/1 is the entry made by accused Manoj Kumar Mahanti. Exhibit 7/2 is my signature and endorsement dated 1/9/99. I seized one cycle, 1 quintal of rice, 1 APL card from accused Narendra Sethi, and I gave the seized articles to police. The ACSO Rairangpur issued the tally register in favor of GP Secretary Bisoi.
So now just keep now the ଆପଣଙ୍କର ଦିଟା क्वेश्चन आंसर देखिले ଆପଣଙ୍କର डिफेन्स प्ली देखिले जो डिफेन्स विटनेस रो स्टेटमेंट आउ ए जो एविडेंस टा देखिले ताले फैक्चुअल एस्पेक्ट रे कोन हला सो फार एज रजिस्टर आउ से जो कार्ड गुडा रजिस्टर रे एंट्री हेची जे 5 जण लोकंग पाइ लेट अस नेम देम ए बी सी डी ई हला ए बी सी डी ई सपक्ष रे सेल रजिस्टर ऑफ द डीलर बा जो मनोज रो सेल रजिस्टर एंट्री हेची जे ए बी सी डी ई को प्रत्येक को 1 तारीख दिन 20 केजी चावल दिया गला हला एवं कहा को किए से चावल रिसीव कला ना दी अदर अक्यूज्ड जहां ना होची नरेंद्र हला नरेंद्र रिसीव कला नरेंद्र होची वन ऑफ देम लेट अस नरेंद्र को ना दे
yes that APL card holder is गंगाधर
सेठी APL कार्ड कोन सी जो 5 जन को भितरु
5 जन भितरु 4 जन अलग आउ जन होची गंगाधर सेठी
No.
that APL card holder is गंगाधर सेठी
No.
not
Narendra ro BPL card अछि and he is one of the 5 persons.
गोटे कार्ड होची यार माने अक्यूज्ड रो नरेंद्र सेठी रो किंतु बाकी जो कार्ड गुडाक सेगुडाक होची तार केस होची जे मते से माने एंट्रस्ट करैथिले मु रिसीव करले
पेज 18
that is also your case also in এটা দিলে এই যে এইটা পেপার বুকটা
the names have been given you also may kindly say 20 page 21 of the judgment matter
जजमेंट कथा छाड़ନ୍ତୁ ମୁଁ ଆସନ୍ତେ ଏଭିଡେନ୍ସ କଣ ଅଛି you read that FIR page 32
Okay. Sir, I beg to report that today, as on 1/9/99, at about 1 p.m., while I was moving in Bisoi Bazar, the villagers of Asan Sikhul, namely Bisweswar Sethi, Chandra Mahkut, and other village Malchan Balangir gave petition at about 1 p.m. to the effect that one Narendra Sethi or
he is the appellant in 21 of
again
yes sir
right
again
21 of 2001 yes
one Narendra Sethi or Asan Sikal was proceeding with rice in a cycle, collecting the same for the Secretary Bisoi retail shop located at
illegible. Hatpadia in Market Complex. Shop number 7 without ration card, and they have detained him with rice and cycle. I inquired into the matter and immediately inquired into the matter, and Narendra Sethi could not produce any document in support of rice except one APL card number such and such, in which no entry has been made about supply of rice today. I also verified the sale register of Bisoi GP and noticed he that's illegible in my file. He had
ସେଇଗୁଡାକ
one
ଇସ୍ୟୁ ଗୁଡାକ ଅଛି ସେ ଯୋଉ କାହା ନାଁରେ ଇସ୍ୟୁ କରିଥିଲା
ଆଜ୍ଞା ସେ ତାପରେ ଯୋଉ ବିପିଏଲ କାର୍ଡ ଗୁଡା କେମିତି ତାକୁ ଦେଲା ସେଇ ପାର୍ଟଟା ଲେଖା ହେଇଛି ସେଠି। ଫାଷ୍ଟ ତ ସେ ଲେଖିଲେ କି one APL
ଏଗୁଡାକରେ ଏଇଟା ହଉଛି ସିଏ ଏଠି କହୁଛି ଆଇ ଅଲସୋ ଭେରିଫାଇଡ ଦି ସେଲ ରେଜିଷ୍ଟର। ସୋ ସେଲ ରେଜିଷ୍ଟର ହେଲା ଓବିୟସଲି ମନୋଜର
ଆଜ୍ଞା
ଅଫ ବିଶୋଇ ଗ୍ରାମ ପଞ୍ଚାୟତ and notice that he has
made entry ଲେଖା
ହଁ
ହେଇଛି।
ସେଟା କଣ ଗୋଟେ ରଖା ହେଇଛି ऐसे
He had sold 1 quintal of rice in 5 ration.
ନାଇଁ ଇଏ ବି ସେୟା ଗୋଟେ କଣ ମାନେ ମୋଡି ମାଡି ହେଇଛି ଚିରି ଯାଇଛି କଣ ହେଇଛି ଯାଉ ଏଠି ଯାହା ଜଣା ପଡୁଛି ସେଲ ରେଜିଷ୍ଟରରେ ଯୋଉମାନଙ୍କର ନାଁରେ ଏଣ୍ଟ୍ରି ହେଇଛି ସେମାନଙ୍କ ନାଁ ଗୁଡାକ ଦିଆ ହେଇଛି
ଆଜ୍ଞା ତା ପର ପେଜ
ତାପରେ ନେକ୍ସଟ ପେଜ କୁ ଯାଆନ୍ତୁ ଆଜ
come of sale register secretary Bisoi GP issued
as Narendra Sethi of village could not produce the ration cards
in support of
PDS. I seized the same 1 quintal
rice and cycle
with the APL card number so and so from him and sale register in so and so.
2 numbers.
Now you come to ये जो स्वप्नेश्वर वो 1 number साखी hostile गला
Lakshmi, kindly see exhibit 9, 10, 11 and 12. Kindly have a glance to exhibit 9, 10, 11, 12.
Go to come to PW2
page 44 minutes. On
yes
on 1/9/99 I was marketing inspector at Bisoi. On
Have
that
you got a type copy of this handwriting? This he has written it by hand. It's not legible that way.
Not legible.
Pardon देखिए कितना I was
MI at Bisoi. On that day I
right. On that day I so and so I found
at
the
Bisoi
villagers
on
of
that
so and so one
went,
Narendra Sethi.
on that day I went to the spot. I found the
wait.
Okay.
Narendra Sethi could not produce the cards in which he had so and so APL rice.
He only showed
I
one
have so and so I received the sale register in 2 volumes, the original sale register and so and so. Okay. Cross examination.
Within 24 hours, I had reported the matter to my authority, and deputant had given a
audio. All right, you come to page 47. Your type is pole asunchari.
Again,
Outer podon.
on 1999, while I was at Bisoi at that time, the villagers gave me a petition as accused Narendra Sethi was taking illegal rice of 1 quintal from accused Manoj Mahanti. Thereafter, I checked the sales center and accused gave an endorsement that he was carrying 1 quintal of rice in 4 BPL and 1 APL cards. Exhibit 4 is the endorsement with signature of the accused on the public petition by accused Narendra Sethi, which is received with objection. On my inquiry, I found accused Manoj Mahanti had given 1 quintal of rice in 4 BPL and 1 APL cards to accused Narendra Sethi, and accused Manoj Mahanti had entered this in a sale register, while APL card number such and such, in the name of Gangadhar Sethi. Accused Manoj had not entered in the said APL card regarding issue of rice, but he has entered the said issue of rice in the sale register. Exhibit 5 is the said APL card. He has not entered in the above APL card but has entered in the sale register on 7/7/99 about sale of rice. Exhibit 6 is the sale register maintained by accused Manoj Mahanti. Exhibit 6/1 is the entry regarding issue of rice to accused Narendra Sethi. Exhibit 6/2 is my signature and endorsement as I had verified the register. On 1/9/99, I had also verified the sale register and found 20 kgs of rice was issued in the name of Gangadhar Sethi, but it has not been mentioned in his APL card.
So 7799 ro এটা ওটা আর একটা incident কথা কইছে. We are not concerned with that because that is not the charge. Charge is 1999 ହେଲା. So 1999 ର ତା ପର line ରେ ଅଛି.
On 1999, I also verified the sale register and found 20 kgs of rice was issued in the name of Gangadhar Sethi, but it was not been mentioned in his APL card. Exhibit 7 is the said register. 7/1 is the entry made by accused Manoj Mahanti. 7/2 is my signature and endorsement. On 1999, I seized 1 cycle, 1 quintal of rice, 1 APL card from accused Narendra Sethi. I gave the seized articles to police. The ACSO Rairampur issued the tally register in favor of GP Secretary Bisoi GP. Exhibit 8 is the tally register. On 27/8/99, 48 quintal of BPL rice was ordered to issue to store agent with a direction to give accused Manoj Mahanti. The store agent had delivered the said rice on 31/8/99 to Manoj Mahanti. Exhibit 8/1 is my signature with endorsement. Card number Etiki in the name of Rabindra Sethi. Card number such and such in the name of Shiba Sethi. Card number such and such in the name of Subhasini Sethi. And card number such and such in the name of Narendra Sethi. Our BPL cards were seized by OIC. Exhibit 9, 10, 11, 12 are the said cards. On the direction of CSO Mayurbhanj, I sold the seized rice and deposited the sale proceeds in the treasury by challan number such and such, dated 3/5/2000. Exhibit 13 is the said challan. On 31/10/99, I received 1 quintal rice from OIC in Zima, but exhibit such. Exhibit 14/1 is my signature. Next page, Manoj. I had kept the treasury challan BPL cards with me till today. On the last day, I had bought the documents with me but did not produce the same in court. Narendra Sethi is not my classmate, not he is my office colleague. I have not given any endorsement in the application of the public of 1/9/99. I have not given the time and date of receipt of the said application. It is not a fact that Exhibit 7 is the endorsement and signature of accused Narendra Sethi. I have not given any endorsement that accused Narendra Sethi scribed Exhibit 7. It is not a fact that I have manipulated Exhibit 7 with a view to file it in this case. On 31/10/99, I took the rice in my Zima from OIC Bisoi PS. I have not filed the document to whom I sold the rice taken in Zima. I cannot give the reason why I had not sold the rice after obtaining the direction from CSO Mayurbhanj till 1/5/2000. It is not a fact that there was no deficit in the stock on 1/9/99. On 7/7/99, 20 kgs of rice have been sold in Exhibit 5. It is not a fact that I am deposing falsehood. I had not examined Gangadhar Sethi in this case. It is not a fact that accused Narendra Sethi had showed me 4 BPL cards on the date of occurrence. On 1/9/99, one Narayan Naik had received 20 kgs of BPL rice in his card number such and such. It is not a fact that I have seized those 5 cards, including Narayan Naik's, from accused Narendra Sethi.
All right, next witness, Pawan.
Okay. Chandra Mahakut. I know both the accused persons. Accused Manoj Mahanti was the dealer cum secretary of Bisoi GP to sell APL and BPL rice. On 1/9/99, I had been to bring rice from the sales center of accused at Bisoi. The other villagers also had been to bring rice at rupees 2 per kg from accused Manoj Mahanti, secretary. Accused Narendra Sethi took 1 quintal of rice from accused Manoj Mahanti, secretary. Accused Narendra Sethi took rice in 4 consumer cards. Then I and others told secretary accused Sri Manoj Mahanti why he had given 1 quintal of rice to accused Narendra Sethi in 4 cards. In reply, accused Manoj Mahanti said that by mistake I had given the said rice to accused Narendra Sethi. I myself, one Mohan and others retained 1 quintal of rice from the possession of accused Narendra Sethi and then informed the matter to the marketing inspector Bisoi block. Then I seized the rice in our presence. He seized 1 cycle, rice and consumer card. Of them, 1 consumer card was in the name of Gangadhar Sethi. He prepared the seizure list by Exhibit 2. Exhibit 2/2 is my signature therein. At the time of seizure, accused Narendra Sethi was present. He has also signed in the seizure list. I am acquainted with the handwriting and signature of accused Narendra Sethi. Exhibit 2/3 is the signature of accused Narendra Sethi. Accused cross-examination. Accused Manoj Mahanti has supplying APL and BPL rice to the consumers. Accused Narendra Sethi took 1 quintal of rice in consumer cards of himself, Subhasini Sethi, Gangadhar Sethi, Sibo Sethi. Accused Manoj Mahanti had the rice in 4 number of BPL card in and 1 APL card to accused Narendra Sethi. I have not remembered the consumer card numbers. On the date of occurrence, the name of Gangadhar Sethi had been entered in the sale register regarding sale of rice in his favor. It is not a fact that the name of Gangadhar Sethi has not entered in the sale register of Manoj Mahanti. On 1/9/99, one Narendra Sethi received 1 quintal of rice in consumer card number. There are 5 consumer card numbers given. It is not a fact that on our question, accused Manoj Mahanti told that he had taken rice in given rice in favor of 4 above persons. My village
जो लाइन टा जोटा पढ़िले जस्ट गोटे लाइन पूर्वरु नरेंद्र सेठी माने से जो अपेलेंट
आगे
से जो 2021
आगे
से नरेंद्र सेठी received 1 quintal of rice in consumer cards number so and so आगे एटा होची स्पेसिफिक माने ये क्वेश्चन मध्य एक्यू स्टेटमेंट रे पचारला दी जण जाक
आगे
दी जण जाक मध्य कहले जे हां सेही नरेंद्र सेठी कहला हां मु एमानक पई नेली मो पई एवं अन्य मानक पई से बानी भी कहले जे माने से मार्केटिंग ये जो जे सेक्रेटरी अर्थात मनोज महांती सी भी कहला जे
ये नहीं छी 5 जन को बिहाफ
तो एया जदी आपनकर केस हुए हाउ योर डिफेंस विटनेस सेज दैट दोज 5 पर्सन्स हैड कम दे रिसीव्ड द राइस जदी राइस ही था तांको सिग्नेचर था ना सेल रजिस्टर रे व्हाट इज योर प्ली
Lordship, he has not stated that. May I read the defense statement?
हाँ पढ़िले पर आउथर पढ़ना दी के
that one line, my lordship. I had, my lordship has it. Page 58. Fifth line I'm reading. I had been to Bisoi to bring my BPL rice from
आगे ऑन टा पढ़ंदु on 19 से गुडा डेट ऑफ
on 1/9/99 I had been to Bisoi to bring my BPL rice from Panchayat. Narendra Sethi, Sibo Sethi, Subhasin Sethi, Rabi Sethi, Narayan had come with me to Bisoi to take BPL rice.
मानकर होची से कार्ड गुडा को नंबर गुडा
आगे had come with me to Biswai to take BPL rice,
ହେଲା
but he has not mentioned if they have received the rice themselves or accused Narendra.
ଆରେ ପଢୁନାହାନ୍ତି ତାପରେ ଦେନ୍
We all kept all rice in one bag.
ହଁ
in-
ରିସିଭ୍ କଲା ପରେ ଗୋଟେ ବ୍ୟାଗ ରେ ଷ୍ଟିଚ୍ କରାଗଲା ତାପରେ ଲୋଡ କରାଗଲା କୋଉଠିକି ନା ଇନ୍ ଦି ସାଇକେଲ ଅଫ ନରେନ୍ଦ୍ର ସେଠୀ ମଧ୍ୟ ଆସିଥିଲା ଏଇ ଯୋଉ ଅନ୍ୟ 4 ଜଣଙ୍କ ସହିତ ତାପରେ ରିସିଭ୍ କରିକିନି ଗୋଟେ ଇଏ ରଖାଗଲା ୟେସ୍ ତାପରେ ପଢନ୍ତୁ at that
time
we all the
BPL consumer card holders were present.
ତା ମାନେ ଏଇ ଯୋଉମାନେ କାର୍ଡ ନେଲେ ମାନେ ଯୋଉମାନେ କାର୍ଡ ସେମାନେ ମଧ୍ୟ ସେତେବେଳେ ପ୍ରେଜେଣ୍ଟ ଥିଲେ ପଢନ୍ତୁ ତାପରେ ପଢନ୍ତୁ
Detained the bag. In the meantime, the marketing inspector came and detained the bag. We all showed all of our respective cards to marketing inspector, but he did not accept our cards. And then he took the full bag rice and accused Narendra Sethi to his office. One consumer card holder was taking 2 months rice at a time, that is 20 kgs each. In previous month, we have not received any rice. The witness identified his card and also other cards. The Panchayat secretary was not giving 1 quintal of rice to 4-5 card holders. In other times, we are taking the rice in a bag of 4 to 5 consumers. Cross-examination, it is not a fact that I am deposing falsely.
ତ ଯଦି ଏଇ ପ୍ଲିଟା ଆପଣଙ୍କର ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ ରେ ନେଲେ ଆପଣଙ୍କର କେସ୍ ହଉଛି ଯେ ନରେନ୍ଦ୍ର ସେଠୀ 5ଟା ଯାକ କାର୍ଡ ଆଣିଲା ଏବଂ ସେମାନେ ସେମାନଙ୍କ ପାଇଁ ଏବଂ ନିଜ ପାଇଁ ରିସିଭ୍ କଲା ରାଇସ୍ ଫ୍ରମ୍ ମନୋଜ କୁମାର ମହାନ୍ତି ଟୁ ଯିଏ ହଉଛନ୍ତି ସେକ୍ରେଟାରୀ ତାପରେ ତାକୁ ଗୋଟେ ବ୍ୟାଗ ରେ ହେଇକିନି କ୍ୟାରି କରି ଚାଲିଗଲା ତାହେଲେ ଡିଫେନ୍ସ ରେ ମଧ୍ୟ ଆପଣ ସେଇ ପ୍ଲି ହିଁ ନବାର ଥିଲା ଏବଂ ତା ସହିତ ଯୋଉମାନଙ୍କର କନଜ୍ୟୁମର କାର୍ଡ ତାଙ୍କୁ ଏକ୍ସାମିନ କରିବାର ଥିଲା ଆଟଲିଷ୍ଟ କିଛି ଜଣେ ଦି ଜଣଙ୍କୁ ଏକ୍ସାମିନ କରିବାର ଥିଲା ଯେ ହଁ ଆମେ ଆକୁ ନରେନ୍ଦ୍ର ସେଠୀକୁ କହିଥିଲୁ ଆମ କାର୍ଡ ଦେଇକିନି ଯେ ଆମର ଏଇ ଅସୁବିଧା ହେଇଛି ତମେ ଆମ ପାଇଁ ରାଇସ୍ ଟା ନେଇ ଆସିବ ତାହେଲେ ଏଇଟା କନସିଷ୍ଟେଣ୍ଟ ହେଇଥାନ୍ତା କିନ୍ତୁ ଆପଣଙ୍କର ଯୋଉ ପ୍ଲିଟା ଆପଣ ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ ରେ ନଉଛନ୍ତି ପ୍ଲସ୍ ଯାହା ବାହାର କରୁଛନ୍ତି ପ୍ରସିକ୍ୟୁସନ ୱିଟନେସ୍ ଟୁ ସେଇଟା କମ୍ପ୍ଲିଟଲି ଡିଫରେଣ୍ଟ ଫ୍ରମ୍ ଦି ଏଭିଡେନ୍ସ ଅଫ ଦି ଡିଫେନ୍ସ ୱିଟନେସ୍ ଏବଂ ଗୋଟେ କାର୍ଡ ର ଏଣ୍ଟ୍ରି ହେଇନି ଆଉ 4ଟା କାର୍ଡ ର ଏଣ୍ଟ୍ରି ହେଇଛି ସେ କାର୍ଡ ବାଲା ଆପଣଙ୍କୁ ଦେଇଥିଲେ ବୋଲି ବର୍ତ୍ତମାନ କିଛି ପ୍ରମାଣ ନାହିଁ ତ ଇଟ୍ ମେ ବି ଦ୍ୟାଟ୍ without their knowledge you have somehow or other brought the card and took their rice on their behalf ଆପଣଙ୍କ ପାଖକୁ ସେ କାର୍ଡ କେମିତି ଆସିଲା ଯଦି ଆପଣ ଦାୟିତ୍ୱଟା ହଉଛି ଆପଣଙ୍କର ନା 106 ର ଯୋଉଟା କି ମିଷ୍ଟର ମିଶ୍ର ପଏଣ୍ଟ ଆଉଟ୍ କରିଥିଲେ ଆପଣଙ୍କ ପାଖରୁ ଯେତେବେଳେ ଗୋଟେ କ୍ୱିଣ୍ଟାଲ ଚାଉଳ ମିଳୁଛି ଏବଂ ଆପଣ ହଉଛନ୍ତି 20 କେଜି କେବଳ ଆପଣ ରିସିଭ୍ କରିବାର ଯଥାର୍ଥତା ଅଛି ତ ଇଟ୍ ଇଜ ୟୁ ହୁ ଆର୍ ଟୁ ପ୍ରୁଭ୍ ଦ୍ୟାଟ୍ 80 କେଜି ବାକି ଯୋଉ 80 କେଜି ଏଟା ଆପଣଙ୍କ ପାଖରେ କେମିତି ଆସିଲା ଆପଣ ଯଦି କହୁଛନ୍ତି ଯେ 80 କେଜି ମୁଁ ସେ ଆର 4 ଜଣ ଲୋକଙ୍କ ପାଇଁ ମତେ ସେମାନେ କହିଥିଲେ ସେମାନଙ୍କ ପାଇଁ ମୁଁ ଏଇଟା ରିସିଭ୍ କରିଛି ତାହେଲେ ସେ 4 ଜଣଙ୍କୁ ତ ଏକ୍ସାମିନ କଲେନି ଯୋଉମାନଙ୍କ ଆପଣଙ୍କୁ ସପୋର୍ଟ କରିଥାନ୍ତେ ଆପଣ ଯୋଉ ସାକ୍ଷୀଟାକୁ ଦେଲେ ସିଏ କହିଲା ନାଇଁ ସେ 5 ଜଣ ଯାକ ସବୁ ଆସିଥିଲେ 5 ଜଣ ଯାକ ଆସିଲେ ସେ ରିସିଭ୍ ହେଲା ପରେ ଗୋଟେ ବ୍ୟାଗ ରେ ତାକୁ ପ୍ୟାକ୍ ହେଇକିନି ଆକୁ କୁହାଉଥିଲା ନେଇକିନି ଯିବା ପାଇଁ ଇଜ ଇଟ୍ ନଟ୍ ଟୋଟାଲି କଣ୍ଟ୍ରାଡିକ୍ଟରି ଟୁ ଇଚ୍ ଅଦର
but ତାର ବି cross examination ରେ he has not been suggested anything जो DW1 ର ଯୋଉ
ସିଏ ନ ସଜେଷ୍ଟ କରୁ ଆପଣ ସେଇଟା ଆପଣଙ୍କର ତା ମାନେ ଆପଣଙ୍କର ଡିଫେନ୍ସ ୱିଟନେସ୍ ଟା ର ଏଭିଡେନ୍ସ ଟା ଅନଚ୍ୟାଲେଞ୍ଜ ରହିଲା ନାଉ ଆପଣଙ୍କର ଡିଫେନ୍ସ ୱିଟନେସ୍ କୁ କମ୍ପେୟାର କରନ୍ତୁ ଆପଣଙ୍କର ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ ସହିତ
there is inconsistency
ତେଣୁ ଯଦି ଆପଣଙ୍କୁ ଅଥରାଇଜେସନ ଦିଆ ହେଇନାହିଁ ଆପଣଙ୍କୁ ସିଏ ଇମ୍ପ୍ରପରଲି ଜଣେ ଲୋକ ଯାହାକୁ ଯିଏ ହଉଛି ସେକ୍ରେଟାରୀ he has been entrusted to distribute the rice and to the proper person maybe he is a BPL card holder or APL card holder ତେଣୁ ତାର ଦାୟିତ୍ୱ ହଉଛି ଯେ ପ୍ରପରଲି ସେଲ୍ ରେଜିଷ୍ଟର ଏଣ୍ଟ୍ରି କରିବ ଏବଂ तांकर जो कार्ड रे मध्ये एंट्री करिकिनी दबो जो ठीक लोक को दबो ओबियसली सिग्नेचर नबो तेणु जदि से लोक मान प्रकृत रे पाऊ नाहांती माने आपण जनक कथा छाड़ दियो ए जो नरेंद्र सेठ गोटे कार्ड अच्छी जो बाकी 80 लोकंकर ना रे जदि से माने से माने पाऊ नाहांती ताहले से 80 केजीटा रो जो ऑर्डर आपण इश्यू कले आपनकर रजिस्टर रे मेंटेन कर देले सो इज इट नॉट वायोलेटिंग द ऑर्डर ऑफ द ओडिशा पैडी कंट्रोल ऑर्डर रे
again those 4 BPL cards entry are there. They are countersigned in the register. Only one APL card register रे entry अछि किंतु कार्ड रे नहीं.
अरे से जो बीपीएल कार्ड रे एंट्री हेची
आज्ञा
से बीपीएल कार्ड रो एंट्री हेची किंतु
जोटा रजिस्टर रे भी अछि
रजिस्टर अछि किंतु से सबु तक इश्यू हेची काहाकू ना ए जो नरेंद्र सेठी को इश्यू हेची से लोक माने अंकर सिग्नेचर सेल रजिस्टर नाही.
आज्ञा but the sale register shows that 20 kgs each rice issue हेची
मु आपण मु जा कहूची बुझी पालेनी आपण पर्टिकुलर लोक आसीबनी
आज्ञा
somehow or other you manage to collect the ration cards
आज्ञा
हैला
आज्ञा
कार्ड करिकिनी तांको नारे एंट्री करी आपण नै जिवे
आज्ञा
हैला से लोकंकर अज्ञात रे
आज्ञा
जदि आपण तांको बिहाफ रे नैथिले से माने आसी कहि परतांदे साखी देइथांदे आमे आज्ञा पठेइतुलु आंकू जे आम पई नै आसीबो तो से लोक मानको नारे जदि अज्ञात रे नै गले
आज्ञा
whether it would not flout the condition of the license
if
that you are supposed to give to the proper persons. Now if you say that proper person has authorized you
आज्ञा
to receive their rice on their behalf, then burden shifts on you to prove the same, and that can be best proved by examining those 4 persons. जो 4 जन लोकों को आपण कार्ड आनिकिनी तांकर रिसीव कले चाउल से 4टा लोक आसिकिनी कहि थांदे जे आज्ञा आमे नरेंद्र को देइथिलु आम पई चाउलटा नै आसीबा काम सरतांदा सेथि पई ना नरेंद्र गला आपनकर टोटल प्ली ही डिफरेंट आ सेथि पई जो एंट्री टा कहउचंदी एंट्री तो अछि
आज्ञा
आपण एंट्री करिकिन देइचंदी किंतु एंट्री करी काहा को दबा कथा प्रॉपर लोकन को दबा कथा अर्थात जहार बीपीएल कार्ड हो बा एपीएल कार्ड जहार थिबा कथा आपण ताकू देबे गोटे कार्ड रे टोटल एंट्री हेनी एपीएल कार्ड रे दैट इज आल्सो दैट हैज बीन एग्जिबिटेड सो से 20 केजी टा आपण जो देई देले ताकू आपण एंट्री कर देले ता धीरे एंट्री हला नाही से कार्ड रे काली से लोक जहा ना रे एपीएल कार्ड अछि से धरि किना आसीबो ता कार्ड टी कहबो मते 20 केजी दियो ताले आपण कोन करिवे तो सेथि पई पैडी कंट्रोल ऑर्डर रे कहिला जे आपण जो जेतेबेले डिस्ट्रीब्यूट करिवे ताकू लाइसेंस रे जो टाइप रो रही छी सेही तार कंडीशन अनुଯାयी देबे तो लाइसेंस रो कंडीशन कोन ना सेटा भी प्रमाण है से कार्ड टा मस्ट हैव बीन प्रूव्ड आल्सो.
Lordship, I just want to show my lordship the page 50, your lordship. Examination of Chandramakhu, the eyewitness. मु जोटी पढुतिली my lordship has it जो 5टा consumer card लिखा है page 50. It is not a fact that in our question accused Manoj Manti told that he had given rice in favor of above persons. My village, this is important. My village is at a distance of 14 kilometers from Bisoi. There is no bus communication from Asankala to Bisoi. We are going by cycle or foot. Generally, if any old man or any person unable to bring rice, one man will take rice from the sales center for other persons. It is not a fact that due to the personal enmity with the secretary, I am deposing against the accused persons and accused Manoj Mahanti was not giving or Narendra Sethi was not giving rice to other persons. It is not a fact that I was asking more rice for myself to Manoj Mahanti, to which he denied to give rice and I am deposing falsely. It is not a fact that Manoj Mahanti had not issued rice in APL card number Etiki and no entry was made in that card in favor of Gangadhar Sethi. This is PW 3, your lordship. So what is
your suggestion? जे मनोज महांती को टोटल मनोज महांती गंगाधर सेठी ना रे टोटल माने डिस्ट्रीब्यूट करी नाहांती ମାନେ
It is not a fact.
ଦେଇନାହାନ୍ତି ତେଣୁ that is your plea.
It is not a fact, he's saying.
Yes.
Yeah.
It's not
That
a fact.
also the
ଆପଣ suggest ଯୋଉଟା କଲେ
Again.
ତାକୁ ସେ ମନା କଲା. Now you come to PW4.
Also, one more point I was showing, my lordship, that if generally if any old man or any person unable
That
to
is there. Who says no? That nobody can take. Only that
On
man
behalf-
has to come and receive.
Again,
Nobody is denying that. Yes, come to the PW4.
PW4 minutes. On 1999, I was BDO at Bisoi block. I know the accused persons. Accused Manoj Mahanti was the GP secretary at that time and was dealing with the APL and DPL rice of the Panchayat. The sales center was situated at Bisoi Market Complex. At the instance of the chairman of the block, I went to the market complex of Bisoi. I found 200 to 300 consumers were gathered near sales center to purchase rice. The public told that they have detained accused Narendra Sethi as he was carrying 1 quintal rice in his cycle from accused Manoj Mohanty. Thereafter, I called the marketing inspector and nodal officer to the spot. At that time, Swapneshwar Mishra was the marketing inspector and Pradyumna Nandi was the nodal officer of Bisoi block. Thereafter, marketing inspector, myself and nodal officer checked the sale registers of accused Manoj Mahanti and we found accused Manoj had given 1 quintal of rice to accused Narendra Sethi in 5 consumer cards.
ହେଲା clear ହେଲା ଏଇଟା ହେଲା
Again,
ମାନେ ଅନ୍ୟମାନେ ଆସିନଥିଲେ obviously
again.
5 ଜଣଙ୍କ ପାଇଁ ତାକୁ ଇଏ ଦେଇ ଦେଇଛି ନରେନ୍ଦ୍ରକୁ ଦେଇ ଦେଇଛି ସମସ୍ତ ଚାଉଳ ଜଣକା ଲେଖା 20 କେଜି ମାସକୁ ପାଇବା କଥା ତେଣୁ ତାକୁ ଦେଇଦେଲା yes ତାପରେ
in 5 consumer cards. Marketing inspector seized the sale registers from the secretary. Accused Manoj Mahanti under seizure list, Exhibit 1/4, Exhibit 1/2 is my signature in it. And then he was declared hostile.
Declared hostile, yeah.
I have not been examined by police. It is not a fact that on 1999, I have stated before the police that the villagers gave a written report before the marketing inspector and at the direction of the BDO, I myself and marketing inspector went to the spot to verify and accused Narendra Sethi did not produce the BPL cards in support of his possession of rice and thereafter he produced the cards after getting cards from accused Manoj Mahanti and 4 BPL cards bearing numbers such and such in the name of Rabindra Sethi, Narendra Sethi, Sibba Sethi, Subhasini Sethi and Gangadhar Sethi were seized by the MI. And also the MI seized the cycle of accused Narendra Sethi. It is not a fact that I have stated before the police that on 7/7/99, the GP secretary issued 20 kgs of rice in 1 APL card and also in the same card, he had issued further 20 kgs of rice illegally. It is not a fact that I am deposing falsely at the instance of the accused persons with a view to save them. Cross-examination. I was not dealing with the APL and BPL rice of the Panchayat secretary. The nodal officer and MI were in charge of the consumer subsidiary rice. I have no direct knowledge about the distribution of APL and BPL rice of the consumers. At the time of occurrence, BDO Bisoi was absent in his office. I have not verified the stocks of rice. Accused Narendra Sethi had taken 1 quintal of rice from accused Manoj Manthi of his villagers for better movement of the rice and for the betterment of the consumers. It is the duty to take rice of a consumer, but there is no provision to take rice for 5 consumers by 1 person. I do not know if the accused Manoj had given the rice to 1 in 5 consumer cards previously on the date of occurrence. 5 persons are coming in one time and were taking 1 quintal of rice in one bag for their convenience. And they were distributing the said quantity of rice in their village in 5 shares. I have not been examined in this case by the police, which is a fact, my lord. They collect 1 quintal of rice, 100 kgs of rice in one bag, and after that they go to the village and then they distribute the rice between themselves, carrying 20 kgs separate.
Next.
PW5. On 20/10/99, I was in my present post. On that day, I took charge of investigation of this PS case number 62 of 99 from the SI DC Nanda. On that day, I sent VHF message to the DM Mayurbhanj cum collector Mayurbhanj for disposal of seized rice. Then I left the seized rice in Zimma of Sapneshwar Mishra, Marketing Inspector Bisoi. After receipt of order bid number 1403, such and such, Exhibit 15 is the letter of the collector, white memo number such and such. I left the seized rice in Zimma of Marketing Inspector Sapneshwar Mishra, weighing about 1 quintal under Zimanama, white exhibit number 14. Exhibit 14 by 2 is my signature on it. I seized the tally register on production by accused Secretary Manoj Kumar Mohanty at the PS, and on such and such date under Caesar list. Exhibit 16, 16 by 1 is my signature. 16 by 2 is the signature of accused Manoj Mohanty on Exhibit 16. After completion of investigation, I submitted charge sheet against the accused persons on 24/12/99. Cross-examination. I have not examined any witness except one seizure witness to the tally register. After taking the seized rice in the Zimma, the MI has not intimated me what he did about the seized rice. PW6. On 1999, I was the OIC at Bisoi PS. On that day at 6 p.m. on the written report of Marketing Inspector Sapneshwar Mishra, I registered this case and directed ASI GB Biswal to take up investigation. Exhibit 3 is the FIR. Exhibit 3 by 2 is my endorsement with signature on it. Exhibit 3 by 3 is the formal FIR drawn up. On 3/9/99, I took charge of this case from the ASI, GB Biswal, and made prayer to the district magistrate cum collector Mayurbhanj for disposal of the seized rice. On 11/9/99, I seized the card bearing number such and such on production by the accused Narendra Sethi and prepared seizure list Exhibit 17. Exhibit 17 by 1 is my signature on it. Exhibit 17 by 2 is the signature of accused Narendra Sethi on Exhibit 17. I arrested accused Narendra Sethi, left the seized BPL cards in Zimma of the accused. Exhibit 18 is the said Zimanama. Exhibit 18 by 1 is my signature. Exhibit 18 by 2 is the signature of accused Narendra Sethi in Exhibit 18. On 12/9/99, I forwarded the accused Narendra Sethi to court. On 20/10/99, I handed over charge of this case to my successor as I was under order of transfer. Cross-examination. I have not examined the card holders of seized BPL cards. I have not made any stock verification. It is not a fact that without investigating into the case properly, I have falsely implicated the accused persons in the case. PW7. On 1999, I was ASI at Bisoi PS. On that day, SI Dhiren Chandra Nanda was the OIC. On the same day at about 6 p.m., the Marketing Inspector Sapneshwar Mishra presented a written report before the OIC and produced 1 quintal control rice along with a bicycle and 1 APL card and 2 sale registers. The OIC registered the PS case number 62 of 99 and directed me to investigate into the case. During investigation, I examined the complainant, seized the 1 old bicycle, 1 quintal controlled BPL rice with a gunny bag, loaded on a Hero Royal bicycle number such and such, 1 APL card in the name of Gangadhar Sethi, son of late Purushottam Sethi of Asansila, in which the last issue date was 12/10/98. Sale register from 31/12/98 to 9/7/99. In original containing 27 pages, of which 22 pages are used by the Secretary Bisoi GP. Another sale register from 22/3/99 to 1/9/99, containing 28 pages, out of which 14 pages are used by the Secretary. 19 is the seizure list. 19 by 1 is my signature. I visited the spot, examined the other witness. Thereafter, I handed over charge of investigation to OIC DC Nanda. PW1 has stated before me that on 1/9/99, accused Manoranjan Mahanti, alias Robbie, gave 1 quintal rice in 4 consumer cards to accused Narendra Sethi, and seeing this, he objected to it. And the secretary abused him in obscene languages, and thereafter he and others obstructed accused Narendra Sethi along with rice and brought them and informed Marketing Inspector Bisoi Block. PW4 has stated before me that on 1/9/99, the villagers gave a written report before the MI at the direction of BDO. He himself and the MI went to the spot to verify, and accused Narendra did not produce the PPL cards in support of possession of rice. And thereafter, he produced the cards after getting the same from accused Manoranjan Mahanti, and 4 BPL cards number such and such in the name of Rabindra Sethi, Narendra Sethi, Sibo Sethi, and Subhasini Sethi and Gangadhar Sethi were seized by the marketing inspector. And also the marketing inspector seized the cycle of the accused Narendra Sethi. Further, he has stated before me that from 7/7/99, the GP secretary issued 20 kgs of rice in one APL card, and the same card he issued further 20 kgs of rice illegally. Cross-examination: I have not examined the Sarpanch, I have not examined Gangadhar Sethi, the card holder. The APL and BPL cards are in same design. I have not examined the nodal officer Padimna Nandi. I have not verified the stock and store of accused Manoj Kumar Mohanty, secretary. It is not a fact that I have not examined the ABDO and the Birsing Naik. It is not a fact that I have not properly investigated into the case and fostered this case against the accused persons. It is a fact, my lords, that the stock of accused Manoj Kumar Mohanty, the alleged dealer, has not been verified. His license has not been seized by the police, neither proved.
कार्ड गुड़ाक मार्क ହେଇଛି କେତେ ମାନେ
exhibit
9 9
9, 10, 11.
देखिले कार्ड टा मार्क कर गोटे कार्ड रे का भଳିଆ ହେଇଥିବ नहीं एग्जिबिट हाँ
ହେଇଛି
9 9
9, 10, 11
गोटे देले कार्ड ते बाहर ଦେଇଛନ୍ତି ब्रो हाँ से गोटे एटा केते नंबर मार्क की जोटा बाहर करছি कार्ड रे मिस्टर मिश्र कार्ड रे सेमती किछि नै जो ओरल एविडेंस कहूनांती जे तमे निजे आसिक नब अर्थात जणे अन्य जन पई नै परिबनी सेमती किछि ए जो कार्ड वर्क अपन एग्जिबिट करछन सेमती किछि नै
That is
तापरे रादर गोटे विटनेस कहूची जदी बुढा ही हेइथिबो बा कोनोसी कारणरू न आसीबो ताहले जेटा बाहर कलो से लाइन टा पर्टिकुलर लाइन टा गोटे कहूनी का कि गोटे साक्षीटे जे
depends on DW1
पेज
नहीं
50
नहीं DW
ना 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 पेज 50 PW3
आपन साक्षी ही कहूची माने
पेज 50 My village is at a distance of 14 km from Bisoi.
Generally, if any 50 रहुचे, generally if any old person or any person unable to bring rice, one man will take the rice from the sale center for other person purpose. तामने जदि बुढ़ा ही जाइथिबो बा कोनोसी कारण पई व्यक्तिगत भाव रे आसिकिन रिसीव करि परिबनी ता पई अन्य जने से कार्ड रे एंट्री करी कि नै परिबो से ताऊ कार्ड टा दबो करि परिबो बट एठी एठी आंकर केस ही होची सेया डिफेंस केस जे से जो आर चार जण आकु देइथिले এবং ये तांग पई रिसीव करि
but
नौ
those 4 card holders they didn't come forward to the
से
court
that is the bottom
examined as DW
हाँ सेटा रादर से माने तांग साक्षी जे कहूची से कहूची से माने आसी थिले
yes they were present
से गुडा से साक्षीटा जो देले से गुडा ही आकु काला काला आर यू फॉलोइंग इट
Lordship. The discrepancy has been brought in
your
by.
defense witness has spoiled your case. You should have examined those card holders. 4 ଜଣ ନ ହନ୍ତୁ ପଛେ ଜଣେ 2 ଜଣ ହେଇକିନି ଆପଣ ଛାଡି ଦେଇଥାନ୍ତେ ଯେ ଆମେ ତାକୁ ଏତିକି ଖାଲି କହିଥାନ୍ତେ ଯଦି ଯେ ଆମେ ତାଙ୍କୁ କହିଥିଲୁ ପଠେଇଥିଲୁ ଯେ ଆମେ ଏଇ ଅସୁବିଧା ପାଇଁ ଆମର କାମ ଥିଲା ପଠେଇଲୁ ଆମେ ତାଙ୍କୁ କାର୍ଡ ଦେଇଥିଲୁ କହିଲୁ ତମେ ଯାଇକିନି ଏ କାର୍ଡଟା ଦେଇକି ନେଇ ଆସିବ ଏତିକି ଏଭିଡେନ୍ସ ଦରକାର ଥିଲା। ଆପଣ ଗୋଟାକୁ ସାକ୍ଷୀକୁ କହିଲେ ସିଏ କହିଲା ଯେ ନାଇଁ ସେ 4 ଜଣ ଯାକ ନିଜେ ଆସିଥିଲେ 4 ଜଣ ଯାକ ନିଜେ ଆସିକି ରିସିଭ କଲେ ତ ତାଙ୍କ ଦସ୍ତଖତ ଥାନ୍ତା ତ ଦସ୍ତଖତ ରହିଛି କେବଳ ଗୋଟିଏ ଲୋକର ଏଇ ଆକ୍ୟୁଜ୍ଡ ଯିଏକି ରିସିଭ କରିଛି ଅନ୍ ଦେୟାର ବିହାଫ। ତେଣୁ ଆପଣ କେସ୍ ହି ଟୋଟାଲ ଏବଂ ଆପଣ ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟରେ ମଧ୍ୟ ହିଁ ସେ ପ୍ଲି ନେଲେ ଯେ ଜଣେ ଆସିଲା ଏମାନଙ୍କ ସମସ୍ତଙ୍କ ପାଇଁ ରିସିଭ କରିକି ନେଲା।
So disbelieve, although it is unchallenged, may disbelieve DW1. Keeping DW1 aside, now from the facts, I am admitting that I had procured.
All right, you let us say that DW evidence टाको हमें छाड़ दवा टोटल ताले आपन को प्ली टा कोन हला जे आपण जणे अक्यूज्ड अर्थात ता ना होची नरेंद्र सेठी
had taken
सीए निजो पाई नेला ता सहित आउ 4 जण को पाई नैथिला या तो आपण केस टा एटा को मध्ये अक्यूज स्टेटमेंट आपण एडमिट कले केवल नरेंद्र सेठी एडमिट कलानी जे ताऊ इश्यू करथला से मध्ये कहला जे नाही हां मु नरेंद्र को ही ए 5 जण को पाई देइथिली राइट तो वर्तमान जदि नरेंद्र को 5 जण को पाई दिया हला ताहले गोटे लोक नेला बेली ताहले से जो नरेंद्र को से माने ऑथराइज करिथिले नबा पाई सेटा प्रमाण की करिवो ए प्लीटा तो आपण नउचंती ना एटा आपण को नॉलेज रे रहिछि 5टा कार्ड रे एंट्री ହେଇछि आपण से 5टा कार्ड को धरिकिन जिंस जाउचंती तो से दायित्वटा कहार जे आपण अन्य 4 जन को पाई मध्य रिसीव करचंती से दायित्वटा कहार प्रमाण करिया को जो 106 ऑन जाय इट इज विद इन योर स्पेशल नॉलेज जे मते मु जेतेबेले जाउथिली मो निजो पाई आनिबा को मते 4टा लोक ए बी सी डी मते कहिले एवं कार्ड देले जाइकिनी तमे आम पाई भी नै आस तले एई जो जिंसडा प्रमाण करैबा दायित्व कहार
Lordship, that burden of special knowledge, if there is something within the special knowledge of the accused,
it is within your special knowledge.
I have to come before and prove my case.
Right.
But that has to be called upon only after the prosecution has discharged its burden of proof.
Prosecution आउ कोन प्रमाण करिवो prosecution तो प्रमाण करई देला एंट्री हेची सेल रजिस्टर रे 5 जन पई जणे रिसीव करिछि 100 माने 101 क्विंटल जाईछि आपण आउ प्रमाण करिला जे आपण को पाखरु आउ जन को पाखरु से को अक्यूज रु 5 जन को राइस मिलिछि मध्य अर्थात 1 क्विंटल मिलिछि हैला तेनु वर्तमान आपण से निज छडा आउ जो 4 जन को पई रिसीव करिसंती बेली तारे सेडा प्रमाण करिवा दायित्व आपण को प्रोसिक्यूशन ते एतिक रे प्रमाण करै देला
मु I have given those 5 cards in support of my plea that I had procured those cards from
you
those.
Could not have given. You could not have given to one person unless you are sure, unless you keep the authorization with you. Unless, how can you know that he mu anikini produce kali 5टा card मोर तादिरु गोटे आउ ए 4 जन को पाई unless I am sure that yes this person has been authorized by those 4 person to receive the card अरे से तांग 4टा कार्ड चोरी करी नहीं आस्तिबो
Lordship, this is of the year 99. As such, authorization letter from give the
authorization letter माने कागज रे होंतु आपण साखी सेइत पई कोची साखी देलेनी authorization letter नाही गोटे लोक केमिति अन्य मानक पई देई देले
which has been corroborated by PW3 who has stated that if there is an old man or any person who is unable
अरे
to
सेरा प्रमाण हितांदा से मानक एग्जामिन करथले जे ए लोकटा ओल्ड थिला ए लोकर आजी काम थिला से सेइत पई से जेतला गां रु गोटे लोक जाउथिला से माने ताऊ कार्ड देई देले एती तो कथा से कहिथांदे ओ कोन
what I am submitting is prosecution hasn't brought something forward to shake my version of the case. What prosecution has not examined any witness to shake my version of the case. I am stating that sei 5 ଜଣଠୁ card ମୁଁ ଆଣିଥିଲି procure କରିକି ତାଙ୍କ ପାଇଁ ଚାଉଳ ନବାକୁ, which is a common practice.
That burden is not on the prosecution. Prosecution has proved their case. Something which is within your special knowledge, it is not the duty of the prosecution to prove the same. ମୁଁ ଆପଣଙ୍କୁ example ମଧ୍ୟ ଦେଇଥିଲି।
ଆଜି ମୁଁ ଗୋଟେ judgment ବି ଆଣିଛି in that regard regarding
ଯଦି ମନେ କରନ୍ତୁ ଆପଣ ଆଉ ଆପଣଙ୍କର ସ୍ତ୍ରୀ ଗୋଟେ ରୁମ ରେ ଶୋଇଛନ୍ତି,
ଆଜ୍ଞା
ସକାଳୁ ଆପଣଙ୍କର ସ୍ତ୍ରୀର ଡେଡ ବଡି ମିଳିଲା,
ଆଜ୍ଞା
ଗହଣା ମିଳିଲା ନାହିଁ,
ଆଜ୍ଞା
ଆପଣ ଫେରାର ହେଇଯାଇଛନ୍ତି,
ଆଜ୍ଞା
ତାହେଲେ ଆପଣଙ୍କୁ ଯେତେବେଳେ ହତ୍ୟା ମୋକଦ୍ଦମାରେ ଇଏ ହେଲା ଏବଂ ଆପଣ ପ୍ଲି ନଉଛନ୍ତି, ରାତି ଅଧରେ କିଏ ଗୋଟେ ପଶିକିନି ମୋ ସ୍ତ୍ରୀକୁ ମାରିଛି, ତା ଗହଣା ଗାଣ୍ଠି ନେଇଛନ୍ତି ଏବଂ ମୁଁ ଡରିକିନି ପଳେଇ ଯାଇଛି, ଏଟା ଇଟ୍ ଇଜ ୟୁର ୱିଦିନ ୟୁର ସ୍ପେଶାଲ ନଲେଜ, ସୋ ୟୁ ଆର ଟୁ ପ୍ରୁଭ ଇଟ୍। ପ୍ରସିକ୍ୟୁସନ ପ୍ରମାଣ କରେଇଦେଲା, ଲାଷ୍ଟ ସିନ୍ ଆପଣ ଦି ଜଣ ଯାକ ଥିଲେ, ଗୋଟେ ରୁମ ଭିତରେ ଥିଲେ, ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଶୋଇଥିଲେ, ସକାଳୁ ସ୍ତ୍ରୀର ଡେଡ ବଡି ମିଳିଲା, ଡେଡ ବଡିରେ ହୋମିସାଇଡାଲ ଡେଥ ହେଇଛି, ତାକୁ କିଏ ମାରିଛି, ତାର ଗହଣା ଗାଣ୍ଠି ମିସ୍ କରୁଛି ହେଲା, ପ୍ରସିକ୍ୟୁସନ ଏତିକି କରି ଛାଡିଦେଲା। ବାକି ଜିନିଷ ଆପଣ ଏଇ ଯୋଉ ପ୍ଲିଟା ନଉଛନ୍ତି, ଇଏ ପ୍ରମାଣ କରିବା ଦାୟିତ୍ୱ ଆପଣ। ତେଣୁ ଏଠି ସେଇ ଟାଇପର କେସରେ ଆପଣ ଯଦି କହୁଛନ୍ତି ଯେ ଆପଣଙ୍କ ଛଡା ଆପଣ ଅନ୍ୟ 4 ଜଣ ମାନଙ୍କର କାର୍ଡ ଆଣିକିନି ତାକୁ ରିସିଭ କରେଇଛନ୍ତି, ସେ ଦାୟିତ୍ୱ ଆପଣଙ୍କ ପ୍ରମାଣ କରିବାର ଥିଲା। ପ୍ରସିକ୍ୟୁସନ କଣ ପ୍ରମାଣ କରିବ? ପ୍ରସିକ୍ୟୁସନ ତ ପ୍ରମାଣ କରେଇଦେଲା ଇସ୍ୟୁ ହେଇଛି, ଆପଣଙ୍କ ପାଖରୁ ମିଳିଛି, ଆଉ ପ୍ରପର ଲୋକ ତାକୁ ନେଇନାହାନ୍ତି।
Ration cards are such that cannot be easily stolen from a family. That is, every month issue 4 ration cards from 4 different families, that they keep that ration card to get their quantity of rice every month. It is not possible for one person to steal everything, come also do the correct entry in the register as
You
well as
see,
in the cards, and not expect those persons to come to
କଣ
the
ପାଇଁ ଆପଣ ତାଙ୍କଠୁ କାର୍ଡ ଆଣିଲେ, ସିଏ ଆପଣଙ୍କୁ କାର୍ଡ ଦେଇଥିଲେ କି ନାହିଁ? ଦିଜ ଆର୍ ଦି ଥିଙ୍ଗସ୍ ୟୁ ଆର୍ ଲିଡିଂ ଏ ହାଇପୋଥେଟିକାଲ ଯେ କାର୍ଡ ନେଇପାରିବେନି, ଇଏ କରିବେନି, ତ
when the entry is done in the register as well as the cards, why it cannot be said
ଜଣେ ଆସିବ ମତେ 100 ଟଙ୍କା ମାଗିବ, ମୁଁ କହିବି ଠିକ ଅଛି ମୁଁ 100 ଟଙ୍କା ଦେବି, ତୁ ମୋ ରେସନ କାର୍ଡ ମତେ ଦେଇକି ଯା, ମୋ ପାଖରେ ଥାଉ, 100 ଟଙ୍କା ଫେରେଇଲେ ମୁଁ ତତେ ରେସନ କାର୍ଡ ଟା ଦେବି। ତା ରେସନ କାର୍ଡ ରହିଲା, ଆପଣ ନେଇଗଲେ, ତାର 20 କିଲୋ ଚାଉଳ ନେଇ ପଳେଇ ଆସିଲେ, ତା ଦେହରେ ସିଏ ଲୋକ 100 ଟଙ୍କା ଦେଇ ପାରିଲାନି, ସେ ଭାବିଛି ବାବୁଙ୍କ ପାଖରେ ତ ଅଛି, ଆଉ କଣ କରାଯିବ, ମୁଁ ତ ଯେପର୍ଯ୍ୟନ୍ତ ଦେଇପାରିନି 100 ଟଙ୍କା, ତା ଭିତରେ ଆପଣ ତ ଇଟ୍ ଇଜ ଅଲସୋ ପସିବୁଲ। ତ ସ୍ପେଶାଲ ନଲେଜ କଥାଟା ହଉଛି ଆପଣ ହିଁ ପ୍ରମାଣ କରେଇବେ ଯେ କେମିତି ଆପଣ ସେ କାର୍ଡ ପାଇଲେ, ଆଉ କିଏ ଆପଣଙ୍କୁ ଅଥରାଇଜ କଲା ସେ 4ଟା ଲୋକଙ୍କ ପାଇଁ। ଅଦରୱାଇଜ ଇଟ୍ ଉଡ୍ ବି ଏ ଭାଉଲେସନ ଅଫ ଦ୍ୟାଟ ଲାଇସେନ୍ସ ଦ୍ୟାଟ ସିଏ ପ୍ରପରଲି ରେଜିଷ୍ଟରରେ ଯୋଉ ଏଣ୍ଟ୍ରି କରିଛି, ଦ୍ୟାଟ ଇଜ ଏ ଫଲ୍ସ ଏଣ୍ଟ୍ରି, ଯେ ଏ ଲୋକମାନଙ୍କ ନାଁରେ ଇସ୍ୟୁ ହେଇଛି ଏବଂ ପ୍ରପରଲି ସେ ଲୋକମାନଙ୍କ ପାଇନାହାନ୍ତି। ଆପଣ ଏ ରାମକୁ ଦେଇଦେଲେ ABCD ପାଇଁ, ସମସ୍ତଙ୍କ ପାଇଁ।
what I am trying to submit, my lords, is that the prosecution at least should have brought out how I have procured the cards. I have taken the name of 5 persons jahatu mo card anichi. The prosecution has not examined.
All right, any other argument you want to advance? That's or file this side, this one
side. I'm just placing the placetum B, your lordship. Evidence Act, Section 106, burden of proving facts, especially within knowledge. Applicability, burden to prove guilt of accused beyond reasonable doubt is on the prosecution. It is only when this burden is discharged that accused could be called on to prove any fact within his special knowledge under Section 6 of Evidence 106 of Evidence Act to establish that he was not guilty. Prosecution has not been able to discharge his burden of establishing beyond reasonable doubt that decidative policy, that's the facts of the case. In that case, the conviction was set aside. What I am submitting, your lordship, in light of this judgment, that it is admitted that this said rice was seized from my possession, but I have provided certain BPL cards to that effect, the entry being done in the register as well as the BPL cards.
The entry has not been done in all the cards. One card
has been left.
So, but for that, let us say 4-3 is okay. 4 is okay. What about that particular
Fifth-
card?
that
How
fifth-
did you receive that card?
That fifth particular card, your lordship, that entry has been done in the register, but is
register
not in the card. Not in
Yes.
the card.
How do you explain that?
If it had not been done in both,
20 किलो ଯାହା 100 କିଲୋ ସେଇଆ ସେଇ 20 କିଲୋ କୁ ଫୋକସ କରନ୍ତୁ ଆପଣ
ଆଜ୍ଞା,
ଛାଡି ଦିଅନ୍ତୁ ସେ
ବାକି
80
ଚାରିଟା,
କିଲୋ
ଆଜ୍ଞା,
ସେଇ ଯୋଉ 20 କିଲୋ ନେଇଥିଲେ
ଆଜ୍ଞା,
ସେ 20 କିଲୋ ପାଇଁ ଯୋଉ ଏପିଏଲ କାର୍ଡ ର ଏଣ୍ଟ୍ରି ହେଇଛି ଗଙ୍ଗାଧରର ମାନେ ସେଲ ରେଜିଷ୍ଟର ଏଣ୍ଟ୍ରି ହେଇଛି
ଆଜ୍ଞା,
କିନ୍ତୁ ସେ ଗଙ୍ଗାଧର ଏପିଏଲ କାର୍ଡ ରେ ଏଣ୍ଟ୍ରି ହେଇନାହିଁ
ହେଇନି।
ତ କାର୍ଡ ଯଦି ଏଣ୍ଟ୍ରି ନ କରିକିନି ଯେ ଆପଣ ଦେଲେ କେମିତି ତାକୁ
ମୁଁ ମୋ ରେଜିଷ୍ଟର ଏଣ୍ଟ୍ରି କରିଛି କିନ୍ତୁ
ଓହୋ।
କାର୍ଡ ରେ କରିନି ଆଜ୍ଞା। That is one I am speaking for the distributor Manoj Kumar Mahanti in criminal appeal number 20 of 2000.
ମୁଁ ଆପଣଙ୍କୁ ସେଇଥିପାଇଁ କହୁଛି କାଲି ଯଦି ଆପଣ ଏଣ୍ଟ୍ରି ନ କରି ଦେଇଦେଲେ ତାକୁ କାଲି ଯାହାର ସେ ଏପିଏଲ କାର୍ଡ
ଆଜ୍ଞା,
ସିଏ ଆସିବ ଆପଣଙ୍କ ପାଖକୁ କହିବ ମତେ 20 କିଲୋ ଏପିଏଲ କାର୍ଡ ରେ ମତେ ଚାଉଳ ଦିଅ ଆପଣ ଦବାକୁ ପଡିବ ନା ନାହିଁ କାରଣ
ମୁଁ ତାକୁ ରେଜିଷ୍ଟର ଦେଖେଇବି ଯୋଉଥିରେ ସିଏ ତାର
ସିଏ ତ ଆସିନି ତାକୁ ରେଜିଷ୍ଟର କଣ ଦେଖିବେ
he had sent someone, he had given
କେମିତି ଆପଣ ପ୍ରମାଣ କରିବେ ଅଥରାଇଜେସନ ଲେଟର ନାହିଁ ତା ଦସ୍ତଖତ ନାହିଁ ତାକୁ ଦେଲେ ବୋଲି ମାନେ ସେ ରିସିଭ କରିଛି ତା କାର୍ଡ ରେ ଏଣ୍ଟ୍ରି ନାହିଁ ଏପିଏଲ କାର୍ଡ ରେ ତାକୁ କେମିତି ଆପଣ କହିବେ ଯେ ନାହିଁ
Lordship, on the last date, my Lordship had seen the LCR. Narendra Sethi ro entry achi on the sale register. Se jo APL card against re in the sale register of Manoj Kumar Mahanti.
ନରେନ୍ଦ୍ର ସେ କାର୍ଡ ଟା ହଉଛି ଗଙ୍ଗାଧର ସେଠୀର
Aଜ୍ଞା, but here
ଗଙ୍ଗାଧର ସେଠୀର ସିଗ୍ନେଚର
ଆଜ୍ଞା,
ସେଲ ରେଜିଷ୍ଟର ରେ ନାହିଁ
ନାହିଁ,
ଆଡମିଟେଡ
ଆଜ୍ଞା,
ଗଙ୍ଗାଧର ସେଠୀର ଏପିଏଲ କାର୍ଡ ରେ ଏଣ୍ଟ୍ରି ନାହିଁ
ଆଜ୍ଞା,
ଆଡମିଟେଡ
ଆଜ୍ଞା,
ଗଙ୍ଗାଧର ସେଠୀ ଏକ୍ସାମିନ ହେଇନାହିଁ କହିବାକୁ ଯେ ମୁଁ ଆକ୍ୟୁଜ ଗୋଟେ ଏଇ ଆକ୍ୟୁଜ କୁ ପଠେଇଥିଲି ମୋ ବିହାଫ ରେ ଯାଇକିନି ରିସିଭ କରିବାକୁ ଆଡମିଟେଡ
ଆଜ୍ଞା,
କାଲି ସକାଳେ ଗଙ୍ଗାଧର ସେଠୀ ଆସିବ
ଆଜ୍ଞା,
କାର୍ଡ ଧରିକିନି ଏପିଏଲ କାର୍ଡ ଧରିକିନି ଆସିବ କହିବ ମତେ ମୋ ଏପିଏଲ କାର୍ଡ ରେ 20 କିଲୋ ମୁଁ ପାଇବା କଥା ମାସକୁ ଚାଉଳ ମତେ ଚାଉଳ ଦିଅ
ଆଜ୍ଞା,
ଆପଣ ଦେବେ ନା ନାହିଁ ଆପଣ କୋଉ ପ୍ଲି ରେ ତାକୁ କହିବେ ନାହିଁ ତୁ ନେଇଯାଇଛୁ କଣ ଆପଣ ଆମର ୟୁ ଆର ଡିଲର ନା
ଆଜ୍ଞା,
ୟୁ ଆର ଡିଷ୍ଟ୍ରିବ୍ୟୁଟର
ଆଜ୍ଞା,
ସୋ ଆପଣ କେମିତି ତାକୁ କହିବେ ତୁ ନେଇଯାଇଛୁ ବୋଲି
my Lordship, ଯଦି ମୋ ରେଜିଷ୍ଟ୍ରିରେ କିଛି ବି ଏଣ୍ଟ୍ରି ନଥାନ୍ତା then ତ I was in the position
ଆପଣ ଯିଏ କାର୍ଡ ରେ ଯିଏ ଆସିଲା
ଆଜ୍ଞା,
ତାକୁ ଏଣ୍ଟ୍ରି ନ କରି ଆପଣଙ୍କର ରେଜିଷ୍ଟରରେ ଏଣ୍ଟ୍ରି କରିଦେବେ ରାମ ଦାମ ସାମକୁ ଚାଉଳ ଦିଆଗଲା ସେଇଥିରୁ ପ୍ରମାଣ ହେଇଯିବ ଯେ ରାମ ଦାମ ସାମ ପ୍ରକୃତରେ ଚାଉଳ ପାଇଗଲେ ଏଇଆ କହୁଛନ୍ତି
Lordship, the person who collects the rice also has to sign in the register. In the sale register,
ଆରେ ସେ ଦସ୍ତଖତ ତ ଥିଲେ ତ ନେଇଥାନ୍ତା ସେ ତା ଦସ୍ତଖତ ପୁରା ନାହିଁ ସେ ଲୋକଙ୍କର
ତାର ନଥାଏ କି ନରେନ୍ଦ୍ର ସେଠୀର ଅଛି is what I'm stating.
ନରେନ୍ଦ୍ର ସେଠୀ କିଏ ନରେନ୍ଦ୍ର ସେଠୀକୁ ସେ ଲୋକଙ୍କ ବିହାପରେ ଆପଣ କଣ ପାଇଁ ଦେଲେ କୋଉ ହିସାବରେ ଦେଲେ କି ଆପଣଙ୍କୁ ଅଥରାଇଜ କଲା ନରେନ୍ଦ୍ର ସେଠୀ ମାନେ ସେଇ ଲୋକ 3ଟା 4ଟା ପାଇଁ ତାକୁ ଦବା ପାଇଁ ମୁଁ ତ ଏଇ ପ୍ରଶ୍ନ ହିଁ ଆପଣଙ୍କୁ ପଚାରୁଛି
Lordship, it has come out that it is common practice. Jadi, if someone from a village, they cannot, it's 15 kilometers away that
all right yes Mr. Mishra
Yes, ma'am.
anything you want to say all right heard the learned counsel for the appellant learned counsel for the state judgment is reserved yes next case
I'm grateful.
yes Mr. Mishra
Item 2.
Item number 2. For the petition in item number 2.
ଆଇଏଟା
ଯୋଉଟା ମଗେଇଥିଲି
you have got the information about the death of
I have just received the IA copy to take instruction.
no I am doing one thing I am asking the concerned trial court once he ଯଦି ସେ ତାର ଆଇଆଇସି ଥ୍ରୁ ରେ ଖବର ନବ ଯଦି ତାର ବାପା ମରିଛି ନା କିଏ ବାପା ଯଦି ମରିଥିବ ତାହେଲେ ସେ ପିରିୟଡ ପାଇଁ ଦବ ଯଦି ନାହିଁ ତ ନାହିଁ ଆଉ
ଡେଥ୍ ସାର୍ଟିଫିକେଟ ହେବା ନେକ୍ସଟ
ଇଟ୍ସ ଅଲ୍ ରାଇଟ୍ ଦେଖନ୍ତୁ
ହରିଶ୍ଚନ୍ଦ୍ର ଯୋଜନାରେ ବି ଆପ୍ଲାଏ କରୁଛନ୍ତି
ଏଟା ଟିକେ ଇଏ କର ଆଇଏ ନମ୍ବର କେତେ ଏଟା 55
ମାଇଲ
CRLA number 314 of 23. IN number 2019 of 2023. This is an application for interim bail on the ground that father of the appellant. Who paragraph election the?
My lord, that is at para 4.
Father of the petitioner, namely Brindavan Jena, died on 21/8/2023. And in order to perform the obsequious ceremony, the presence of the petitioner is very much necessary. In support of the contention, the learned counsel for the petitioner has annexed the certificate from the Sarpanch of Ranipada Gram Panchayat dated 22/8/2023. So also the death certificate.
Death certificate ନୁହେଁ ସେଟା ହଉଛି ହରିଶ୍ଚନ୍ଦ୍ର ଯୋଜନାରେ ଯୋଉ ପଇସା ମିଳୁଛି ଆଜିକାଲି ସେଇଟା.
Acha, so also a certificate issued under the Harishchandra Yojana. The learned counsel for the state who has received the copy of the interim application submitted that he has not received instruction about the authenticity of the documents annexed to the interim application. So also the averments taken in the interim application. Considering the submission made by the learned counsel for the respective parties, the averments taken in the interim application and the documents annexed thereto, I am inclined to release the petitioner on bail for 2 weeks from the date of release, subject to condition that before accepting the bail bond, the learned trial court, that is Session Judge cum Special Judge Noyagarh, in TR case number 4 of 2011, shall obtain instruction from the inspector in charge of Kuthana.
ଏଟା ଖଣ୍ଡପଡା ଆଜ୍ଞା, ସେ ରହୁଛି ଖଣ୍ଡପଡାରେ ଥାନା ଅଣ୍ଡରରେ, କିନ୍ତୁ କେସ୍ ହେଇଥିଲା ନୂଆ ଗାଁରେ ଥାନାରେ, ତେଣୁ ଖଣ୍ଡପଡା ଥାନାରୁ ମାଗିଦେଲେ ଜଣା ପଡିଯିବ.
Just a minute. Judgment and judgment. এটা সেই আইটেমটা বাহার করলো তো 50
314
ମୋର ଆପିଲ ମେମୋର ପେଜ 2 ରେ ଲେଖିଛି ପିଏସ୍ କେସ୍ ଟା, ନୂଆ ଗାଁ ପିଏସ୍ କେସ୍ ନମ୍ବର 13 of 2011.
Just a minute. ଦାଶରଥୀ ଜେନା ଘରଟା କୋଉଠି?
ଦାଶରଥୀ ଜେନା ଘର ଖଣ୍ଡପଡା.
ଖଣ୍ଡପଡା. ଓକେ,
ରାଣୀପଡା ପିଏସ୍ ଖଣ୍ଡପଡା.
ତାହେଲେ ଖଣ୍ଡପଡା ଥାନା ଏଇସିଟୁ ହବ ଇଏ
ଆଜ୍ଞା ଆଜ୍ଞା.
The learned and trial court shall obtain instruction through the IIC Khandapada police station about the correctness of the same, and if it is found to be correct, then the bail bond shall be accepted.
Right.
The matter be listed in the 2 ସପ୍ତାହ ଛାଡିଦେଲେ ତାପରେ we commencing from 11th କରିଦିଅନ୍ତୁ. 11th of September 2023, the learned counsel for the petitioner shall produce the surrender certificate of the urgent certified copy.
Oblige.
এটা 55 ର ଯୋଉ ଦିଟା ଆଇଟମ ଅଛି, এটা ସେକେଣ୍ଡ ଆଇଟମ ନା, ସେକେଣ୍ଡ ଆଇଟମଟା ଏଟା 314 ରେ ନା 2 weeks bail granted. Yes.
In item number 2, your lordship, last time your lordship has ordered that the revision is maintainable. Matter was amicably settled between the parties and the parties are present here.
Just a minute. This is item number 2. What is the order dated? Okay. Or the learned counsel for the petition counsel and counsel for the informant or in persons of the order dated so and so. Learned counsel for the petitioners have placed the provision under section so and so to show that revision is maintainable. If the grammar Nyala has passed only a sentence of fine not exceeding 1,000. Learned counsel so and so, since the fine amount in this case is 800 in total for the offense under section 323 and 341. अच्छा केते का देर केते फाइन हिची
600 टंका फाइन ହେଇଛି
टोटल
Under section 341, 323 and 34, it has been fined 600 rupees.
341
323 and 34 for 5 people. 600.
Page 9, Miller.
page 9.
Yes.
So 323 by 34 it is 600.
600. 341 by 34, 200.
341 by 34 hela 200 तामने हेला 800 सेटा कोछे 1000 देखी से जो येटा प्रोविजन टाको
My lord.
केते सेक्शन
33, subsection 2 of clause B.
33
My lord, page 14.
no appeal shall lie if he has pleaded guilty gram न्यायालय passed only a sentence not exceeding acha okay तामने रिवीजन लाई करी okay तापरे कोन हला फर्दर ऑर्डर कोन पास हेची
Hello, we are file an IA.
counsel for the petitioners has filed an interim application right so and so which is an application for compounding the offences wherein it is mentioned that with the intervention of the village entries both the parties have compromised the dispute among themselves and since the offences are compoundable in nature this court may allow the petitioners to compound the offences. The signatures of the petitioners number 2 and 3 appear in the said petition along with the signature of the informant. It is stated that the petitioner number 1, Naran alias Naran, is dead. Okay. Land counsel for the state shall obtain instruction whether petitioner number 1, Narano alias Narayan Behra, is dead or not, and whether there has been amicable settlement between the petitioner number 2, Konthamali, 3, Kuna alias Purnachandra Mali, and the informant Sukanti Mali, through inspector in charge of Chandanpur police station. Aile instruction asila?
Yes, yes.
Aye.
Just.
Yeah.
Hotel. Net on the.
ସେମାନେ ଆସିଛନ୍ତି
Yes.
ଡାକ ଡାକ ଡାକୁଛ ସାମ୍ନା କର ଆଗୁ ଆଗୁ କଣ
In between, the petitioner number 1 has been died.
ସେଇଟା ସେଇଟା ଅଛି ମୁଁ ସେଇଥିପାଇଁ ଲେଖିଛି ସେମାନଙ୍କ ସବମିଶନ ହିଁ ସେଇଆ ଥିଲା ଆପଣଙ୍କୁ କୁହାଯାଇଥିଲା ଇଏ ଇନଫରମାଣ୍ଟ କଥା ପରେ କରି କଣ୍ଠମଲ୍ଲି କିଏ ଇଆଡେ ଆଗକୁ ଆସ ଆପଣଙ୍କ ପାଖରେ କଣ ପ୍ରମାଣ ଅଛି ଆପଣ କଣ୍ଠମଲ୍ଲିକ ବୋଲି ବାପା ନା କଣ ଘର କୋଉଠି ଥାନା यार कॉपी रखियो अच्छा से कुना ओरफ पूर्णचंद्र भोई आगु आस बापा ना कौन अच्छी बापा अच्छी घर कोठी केस रो इनफॉर्मेंट किए आपण ना सुकांती कार्ड कहीं बापा ना कौन आपनकर आपण एमानक संगे अच्छा ये नारायण बेहेरा बंची ना मरलाणी तांको नारे केस करथिले जो आपण मरि गेलाणी आ आपनकर मिलामिशा हो जाईची किछि ସ୍ୱଇଚ୍ଛାରେ କରିଛନ୍ତି ତ କିଛି ଧମକ ଚମକ ଦେଇକିନି ହେଇନି ତ ବର୍ତ୍ତମାନ ତାଙ୍କ ନାଁରେ ଯଦି କେସ୍ ଟାକୁ ଖାରଜ କରି ଦିଆଯାଏ ତାଙ୍କୁ ଯଦି ଖଲାସ କରି ଦିଆଯାଏ ତାହେଲେ ଆପଣଙ୍କର କିଛି ଆପତ୍ତି ନାହିଁ? ଆଚ୍ଛା, ଆପଣଙ୍କ ରିପୋର୍ଟଟା ଦେଖି ଏକୁ ନେଇକି ତାର କପି ରଖିକି ତାଙ୍କୁ ଦେଇଦବ ତାଙ୍କର ଅରିଜିନାଲ ଗୁରା। Yeah. লিখুন criminal revision number 219 of 2010. Three accused persons, three petitioners for them. Namely, Narano alias Narayan Behera, Kantho Malik, and Kuna Bhoi faced trial in the court of Nyadhikari Puri in GR case number 1233 of 2005, oblique trial number 126 of 2009 for offences punishable under section 294, 323, 354, 379, 506 by 34 of the Indian Penal Code. LCR to the The said case arises out of Chandanpur PS case number 101 dated 29/9/2005, which was instituted at the instance of Srimati Sukanti Malik, wife of Naran Malik of village Daso Gobo, Bosanto Mala, PS Chandanpur, District Puri. The London Trial Court judgment by judgment and order dated 4/2/2010 acquitted all the petitioners of the charges under section 294, 379, 354, 506 by 34 of the Indian Penal Code. However, found them guilty under section 341, 323 by 34 of the Indian Penal Code, and sentenced each of them to pay fine of rupees 600 for the offense under section 323 by 34 of the Indian Penal Code, in default to undergo SI for 20 days, and also to pay a fine of rupees 200 each for the offense under section 341 by 34 of the Indian Penal Code, in default to undergo SI for 5 days. Since the Nyala passed a sentence of fine, no, you scroll down it. Not exceeding 1,000 rupees in view of section 33 of the Gramo Nyala's Act 2008, the revision petition has been held to be maintainable as per order dated 17/8/2023. Learned counsel for the petitioners filed an interim application by IN number 544 of 2020 for compounding the offences, wherein it is mentioned that with the intervention of the village gentries, both the parties compromise the dispute among themselves, and since offences are compoundable in nature, prayer has been made to allow the petitioners to compound the offences. The signatures of petitioners number 2 and 3 appeared on the interim application, so also the signature of the informant. It is also stated that the petitioner number 1, Naran alias Naran Behra, is dead. By order dated 17/8/2023, the Learned Counsel for the state was asked to obtain instruction whether the petitioner number 1, Naran alias Naran Behra, is dead or not, and whether there has been amicable settlement between the petitioner number 2, Kantamali, and petitioner number 3, Puna alias Purnachandra Bhoi, and the informant Sukanti Malik through the inspector in charge of Chandanpur police station. Today, the Learned Counsel for the state has produced the written instruction received from IIC Chandanpur police station dated 18/8/2023, from which it appears that the petitioner number 1, Naran alias Naran Behra, died on 17/5/2010 due to illness, and there has been amicable settlement between the parties. The written instruction along with the documents filed by the Learned Counsel for the state are taken on record. The petitioner number 2 and 3, so also the informant, appeared in court today, and they produced their Aadhaar cards, and they were also identified by their respective counsel, and on being asked, both the parties submitted that there has been amicable settlement, and the informant stated that she has no objection if the accused persons are acquitted of the charges. There is no dispute that both the offenses are compoundable in nature. Judgment টা পড়া লাগে দেখি সিআরপিসিটা দিন in view of section 320 CRPC. Subsection 6 of section 320 provides that a high court provides inter alia that a high court acting in exercise of its power of revision under section 401 may allow any person to compound any offense which such person is competent to compound under this section. Subsection 8 of section 320 of CRPC states that the composition of an offense under this section shall have the effect of an acquittal of the accused with whom the offense has been compounded. Since the matter has been amicably settled between the parties and the offenses are compoundable nature, I ordered the in the interest of justice the parties to compound the offenses accordingly. The prayer is allowed. The in view of the compromise, the petitioner number 2 and 3, namely so and so, are acquitted of the charges under section 341, 323 by 34 of the Indian Penal Code. You were on bail during oh no, there shall be stay of relation of when there was no. All right. Accordingly, the revision petition is allowed. Council को ना लिख देना. यांको पाई की appear करछंती और तांक पाई informant पाई की appear करछंती Mr. Tripathi को ना भी लिखिले हला.
Obliged.
आपण माने जानतु गाँ रे भलो से मिलीमिशी रहिबे. Yeah.
Item number 3.
Yes, sir, please, your lordship. Oh. My lord, the appellant.
Yes, just. So you come to the accused statement.
My lord.
Page 49, ma'am.
You are the JE
My lord.
of Jaleshwar Irrigation Subdivision.
Section 1.
The period is 1910-87 to 22/7/1992.
My
So
lord.
that is admitted.
My lord.
Then you are in charge of junior engineer of the construction work of creek irrigation
Yes, ma'am.
My lord.
through Chittei and Gosala
Nole.
Nale,
Nole.
a construction of a foot bridge near Kharid Shak undertaken by contractor Brundavan Kumar De, that you admit.
Bundavan Charan De, ma'am.
Brundavan, see, Charan De, okay.
Ma'am.
Then PW2 evidence is the JE that you received surplus unutilized 4.03 quintal of MS rod of different sizes from contractor Bundavan Charan De. You said yes.
My lord, PW2 has not stated anything like that.
This is what the accused statements.
You have stated that question has been put neithili beli koile pra.
Yes.
PW2 kichi kahi nahanti.
Dekhiba,
PW2
verify
has
kariba.
not.
So it all right, I'm just marking it. It of the Q3 टा ଟିକେ ଏଟା ଇଏ କର. Okay, just keep it. Now PW2 evidence and charge paper. Through ja jana purchi that while handing over the charge to PW2,
Yes.
and the date is 23/7/1992, you did not hand over the charge, said 4.03 quintal of MS iron rod to him. So, एटा आपण कहले your answer is charge handover करथिली iron rod भी देइथिली. एटा हला आपणकर plea.
My lord.
तापरे next question गोटे छाड़ी दियंतु, next question को आसंतु. Question number 6.
My lord.
It further transfer from the evidence of PW2 that in the site account register closing balance of the steel rod has not been mentioned in page 33, and without taking his signature, you have put your signature for both handing over and taking over the charge of the articles. Transaction nil thiba heturu closing balance lekhi nahi. So now you come to your defense plea. Apanokro defense plea hochi je apan charge handover करला बेले iron rod देइथिले.
My lord.
जदि iron rod देइथिले PW2 receive करथिला ताले obviously charge ये रे तांकर रहिबा कथा. से जो जिंस charge रे नेले कारण सी पुनी तांको सक्सेसर को देबे जहा तादिरो खर्च करथिबे जहा आसीथिबो तार भी देबे. तो तांकर किछि जहा जणा पडुची तांकर किछि सिग्नेचर नाही जे सेई जो 4.0 केते क्विंटल रो आयरन
4 quintals 3 kgs.
4.3 kg.
Yes.
4 क्विंटल 3 kg. रो आयरन रोड सी तांकु आपण हस्तांतर कले बोली किछि नाही. सेटा मध्य स्टोर रे नाही. तेणु वर्तमान आसिला जदि आपणकु कॉन्ट्रैक्टर बाकी काम करी एतिकी फेरई देइथिला 4 क्विंटल 3 केजी रो रॉड आपण ताकू नेइथिले बेली मानुचंती एवं आपणकर जे सक्सेसर ताकू से चार्ज आयरन रॉड चार्ज देई नहांती ताले आपण एक्सप्लेन करिवे जे 4 क्विंटल 3 केजी रॉड आपण कले कोन आ जदि किछि करि नहांती आपणकर स्टोर रे नाही ताले आपण ताको आत्मसात करिसेंती बेली प्रोसिक्यूशन केस.
My lord.
So how do you meet this evidence in view of, keep in mind, just focus it. You have admitted that you have taken the 4.03 quintals of iron rod from Brindavan Charan De.
Yes.
Brindavan has been examined.
My lord, no.
Contractor has not been
Not,
examined,
not
Just
at
a
all.
minute. Okay.
but has been examined by the IOM, but not
No,
in the court.
Court.
No, my lord.
Just-
Not been examined.
Okay, Mr. Rizvi,
My lords.
what he says that this particular question number 3,
Yes.
that it transfer from the evidence of PW2,
Successor, my lords.
right?
Yes.
That you had received the surplus oblique unutilized 4.03 quintal of MS rod of different sizes
Yes.
from contractor Vrindavan Charan De.
Yes.
That is not there in the evidence of PW2.
It is there.
It is there. Please come to that line.
My lords. PW2, my lords, your lordship may kindly come to page 56.
56. Okay.
He is the successor of the appellant.
সেই particular লাইনটা মতে দেখান যা বেସିସରେ ଟ୍ରାଏଲ କୋର୍ଟ କ୍ୱେଶ୍ଚିନ୍ ତାଙ୍କୁ
My lords,
କରିଛନ୍ତି
the page 56, your lordship may kindly come. This is only one para. The sentence starting with, at the time of handing over charges. It is just after that BB Das is marked exhibit 9/2, full stop. Then the sentence start with,
yes
at the time of. Lordship got it, my
Right.
lords? Lordship got it, my lords?
yes
At the time, may I just place it?
at the time
Yes,
of
at time of handing over charge, BB Das did not hand over charge some articles which have been categorically mentioned in the charge report. At page number 12, item number 1 of the balance statement of side account was not handed over to me by BB Das. The said entry of page 12 is marked exhibit 9/3. This is the side account register book. When it is written side account, it will be site account, SITE it will be. This is the site account register. This transpires that the articles have not been handed over.
Good.
And this, he says, at the time of handing over charge, BB Das did not hand over charge some articles. Some articles he refers to this 4.03.
ସିଏ ନିଜେ ଆଗେ ରିସିଭ କରିଥିଲା କ୍ୱେଶ୍ଚିନ୍ ଟା ହଉଛି ସିଏ ନିଜେ କଣ୍ଟ୍ରାକ୍ଟର ଠୁ 4 କ୍ୱିଣ୍ଟାଲ 3 କେଜି ଆଇରନ୍ ରଡ୍ ରିସିଭ କରିଥିଲା ଏଇଟା PW2 ର କହିଛି ବୋଲି she makes a categorical statement that PW2 has nowhere stated that the appellant received such iron rods from the contractor. ତେଣୁ ମୁଁ ଆପଣଙ୍କୁ ସେଇଥିପାଇଁ ପଚାରିଲି କୋଉଠି ସିଏ କହିଛି ଯେ ସେ କଣ୍ଟ୍ରାକ୍ଟର ଆଣି ଏଇ appellant କୁ 4 କ୍ୱିଣ୍ଟାଲ 3 କେଜି ରଡ୍ ଦେଇଥିଲା କୋଉ ଲାଇନ୍ ଟା ଦେଖାନ୍ତୁ. Otherwise you cannot put a question if it is not there in the evidence. How can you put a question under 313 statement?
My lord, just continue the reading of this position, my lord. In this register, my lord, may I just place it?
Yeah.
Koda the page 56. At time of handing over charge, then I am continuing the rest portion, my lord. It will transfer from the rest of the deposition of this PW2. At time of handing over charge, BB Das did not hand over charge some articles which have been categorically mentioned in the charge report. At page number 12, item number 1 of balance statement of side account was not handed over to me by BB Das. The said entry of page 12 is marked exhibit 9/3. This is the side account register book. In this register, the quantity of steel iron rod opening and closing balance are mentioned. But in this register, only opening balance of iron steel, though has been mentioned, closing balance has not been entered, and in the same manner it has been mentioned in our charge report at page 12 in serial number 1. The register side account register is marked Exhibit 10. The closing balance of steel rod has not been mentioned at page 33 of this register. The entries of page 33 is marked Exhibit 10/1. Further, in this register, in place of signature of taking over, my signature is not found, and B.B. Das, the appellant Malas, has put his signature for both handing over and taking over. This entry of page 33 also bears signature of B.B. Das. This is the letter of executive engineer to Vigilance Department regarding cost of steel rod. This letter is marked Exhibit 11. It bears the signature of executive engineer M.D. Dhal. I am well acquainted with signature of M.D. Dhal. The signature is marked Exhibit 11/1. As per this letter, the total valuation of iron rod is rupees 5,420. As I did not receive such item, I reported this matter to the SDO after 1 month. Basing on my report, the SDOs issued a letter to B.B. Das on 19/11/92. This letter is marked Exhibit 12. It bears the signature of SDO Bhavani Charan Panda. The signature is marked Exhibit 12/1. This letter was given through me to B.B. Das, for which I mentioned letter number and sent the same through peon, and I also signed the letter. The signature of the witness is marked Exhibit 12/2. B.B. Das refused to accept the letter from the peon. The concerned peon intimated to that effect in the separate letter. This letter is marked Exhibit 13. I informed this fact to SDO on 27/11/92 by a separate letter. This letter is marked Exhibit 14. It bears my signature.
You are not, Mr. Rizvi, you are not pointing out that particular line. What you are pointing out, that he has made the entry himself. He should have mentioned that the charge, in the charge also, the signature of PW2 should have been there. So, question is that unless entrustment is proved,
yes,
409 cannot be attracted.
Admittedly.
How can you prove entrustment unless you prove that X has in fact given that iron rod to the appellant and he is to account for the same?
Yes.
So if there is no evidence on record that he has received that 4 quintal 3 from the contractor,
yes,
how can a trial court put question on that to the accused? And even if he says yes, but let us say that he has stated yes, so admission is there, but question is that whether the evidence is there or not. Unless you adduce the evidence, your putting question is illegal. That question is totally to be discarded. Unless a incriminating material is there, you cannot put a question on that. So where is the evidence? That is why she pointed out that PW2 nowhere stated that the contractor handed over 4 quintal 3 kg of iron rod to the appellant. That's why I am asking you, please show the line. If it is not the oral evidence, whether there is any documentary evidence to show that the particular contractor has handed over such quantity of iron rod to the appellant. That's all. Yes.
And PW2 has not stated, admittedly, but
how it cannot be taken lightly. How then come to the question again? Yes. Accused statement.
Page 49, members.
It transfer from the evidence of PW2 J. Arun Kumar Panda that you have received surplus oblique unutilized swan so of different sizes from contractor Bundavan Charan De. What have you got to say? If your contractor has not been examined, if PW2 has not seen when, because he was not there.
Not there. He was the successor.
Right. He was the successor. Yes. He had not seen when Vrindavan handed over. He is not saying that I have seen.
No, he is not.
Okay. So that is not within the personal knowledge.
Yes.
You are not proving any document to show that on such and such date, this particular iron rod came to the possession of the appellant. So unless you prove it either by oral evidence or by documentary evidence, how the entrustment aspect would come,
Yes.
so that I can explain that it was not there, so I have misappropriated.
In that regard, my lords, entrustment exhibit 10, your lordship may see.
Exhibit?
Exhibit 10, this is the site account register.
Yes.
In site account register, it has been mentioned that he was in possession of this much quantity of iron rods, 4.03.
That is, he may be possession of so and so register, but your particular case is that those were the what he has misappropriated is the extra rod, unused rod. Yes. After the work, this was returned to him, and this particular rod was not accounted for.
Yes.
Because the charge was not handed over, it was not found in the store. So obviously it is misappropriated. Yes. That is your case.
Yes.
So merely because in the store register,
yes,
4 point so and so was shown on a particular day, yes, let us say, yes, Exhibit 10.
Yes.
We'll go to that, Exhibit yes, 10. How can you say that that was the rod which was given to the appellant by that particular contractor?
Then your lordship may kindly see, as for the entrustment part is concerned, the accused himself has admitted that he has.
Again, you are going, Mr. You suppose accused admit, in the accused statement, accused admit that he has killed. Let us say that he has killed a person. You are not adducing any evidence. He has a charge frame, is said no, I am not. You adduce no evidence. When you adduce no evidence, no witness has stated this. Suppose you put a question,
yes,
that X and Y has stated that you have killed him. How the irrelevant things which has not come on evidence, maybe that is there in the case record or that is there in the 161 statement, but unless witness comes forward or there is anything in the document,
yes,
and from that the trial court finds that this is the incriminating material which is available against the accused, so opportunity is to be given in the 313 statement to explain the same.
yes.
So if there is no evidence, how can you put a question on that? And if the answers, say, let us say he has given an answer, your putting of question is not permissible. Your putting of question is illegal. So that is that question and that answer is to be totally taken out of record.
We have documentary evidence to that effect. Exhibit 10 I am banking upon. The site account.
I'll go.
Yes.
We'll take up this matter
yes,
after lunch, okay?
Done.
Pardon, my lord, item number 62. There is my name was reflected as per the appellant advocate, my lord. Earlier I was conducting.
Then you cannot. You should not.
That's why my senior will conduct this matter, my lord, and let it come next week, my lord.
Which item you are telling?
My lord, 62. Item 62, my lord.
Yes, just a minute. Item 62
My name may be.
Right. Your name should. (62) CRL number 291 of 2015. Jyotsna Rani Tripathi, an additional standing counsel for the Vigilance Department, submits that though she has been entrusted to argue the appeal on behalf of the state of Odisha, but she was the counsel for the appellant at one point of time, and therefore she doesn't want to argue this matter, and the matter will be argued by Mr. Sriman Das, Lenin Senior Standing Counsel for the Vigilance Department, and her name may not be reflected in the cause list henceforth. Accordingly, the name of Mrs. Jyotsna Rani Tripathi shall not be reflected in the cause list as the counsel for the appellant, and the matter be listed on 31st of August 2023. है ना?
Right.
Oh, bless.
हाँ. Yes. Yes, Harbo.
My lord, my Narayan friend was uh, trying to show exhibit 10. I,
Which one?
Your lordship's specific query was regarding the entrustment, my lords.
Right.
My lords. So I was relying on exhibit 10, which is the site account register. Lordship may kindly see the exhibit 10.
Just.
Before that, can I draw my lordship's kind attention to the accused statement for a while? May I draw your lordship?
Okay, you make your submission, accused.
Accused statement, question number 14, page 52.
My lord, inadmissible that will be. आयोग को पचारचंती आयोग को पचारचंती
So can we have a glance at it for once?
Accused statement.
Yes, question number 15. 14, my lord, sorry. 14. Page 52 of the paper book.
Okay.
May I just place it, my lords?
Question number 15.
14, my lords. 1-4.
Yeah.
It transpires further from the evidence of PW10 IO that during his investigation, he had examined contractor Brundavar Chandra De, and that the contractor had stated before him that he had returned the excess iron rods after completion of the aforementioned constructions work to you. What have you got to say?
How can you put a question like this? How the trial court can put a question once a witness has not been examined and his statement, if at all been recorded, it is not a substantive piece of evidence. How can the trial court put such a question? Question number 14.
My lords, PW10 has given a categorical finding to this effect in his deposition, my lords.
PW?
10, my lords, the IO. Page.
PW10 has no personal knowledge. He has examined a person whom you have not examined during trial, and it is alleged that such person has stated something. How can that be admissible unless that person is examined? The learned counsel for the defense is given an opportunity to cross-examine him. Are you not using that statement? If I rely on this question and answer, is it not that I am relying on 161 statement of a person? Is it permissible?
No.
It is not substantive evidence. So, if I then there is no question of producing any witness in the trial court. Your IO will examine everybody, and you will put accused statement on the basis of such statement, 161 statements.
Then my lord,
so that question goes. You come to that. What you are showing?
Exhibit 10, my lords, the site account register.
Exhibit 10, Konbar. Exhibit 10 दियो ठीक आधे कौन जाना पुण्य को अच्छा साथ है पता तो
Those relevant pages of the site account register is page 32 and 33. There is the entry for the month of July 1992.
32.
That reveals that on 23/7/92, the accused had received this much quantity of rods. Page 32 and 33, Exhibit 10, site account register. Entry that has been made for the month of July 92, my lords.
Yes, 33 actually July 92. 32 टा होची June 92.
My lords.
June 92 ର position ଦେଖଉଛି ଯେ 10 millimeter diameter ର ये ରହିଛି 0.58 ଏଟା ହେଲା 0.25 swans. Then for the month of July.
Yes, ma'am.
Source of receipt OB 0.58 0.25, 0.94 वाला 2.24 এটা ମିଶିକି ନଉ 6 4 10 10 5 15 15 8 23 3 ହେଲା 2 2 2 4 4 9 13 13 2 15 15 5 20 0 ହେଲା 2 2 2 4 4.03
4.0
তো এই ଯୋଉ ବିଭିନ୍ନ ଡାଇମିଟର ର ଆଇରନ୍ ରଡ୍
total comes to 4.03
ଏଇଟା ଜେଇ ର ଦସ୍ତଖତ ଅଛି P.P. Das.
the appellant.
Okay. Handed over for the month of so and so. For the month of August so and so. OB nil. P.P. Das has not handed over the still in charge paper. Hence the transaction for the month is nil. এই ডকুমেন্টটা কি প্রমাণ কলা এক্সিবিট 10 টা
But the IO has proved it.
PW2 has stated question has also been put in question number 6.
PW2 mark. Page 57. EW2 approved.
So how do you explain it?
My lord, please have a glance at Exhibit 10 itself.
Yes, I'm holding that.
There's not a single sign that the contractor BC they have entrusted
No,
the said rods.
It is
And-
your handwriting, and you have mentioned
My lord.
what are the quantities of rod of different that is available with you, and you have mentioned also transaction during the month is nil. If the transaction is nil, then those stocks should have been present, and it should have been handed over to so and so. So, and the person to whom you will hand over the charge, he should receive it. Yes, I received the aforesaid stocks. So that endorsement is not there. You yourself has written, handed over, and your signature is taken over. Also, your signature handed over. Also, your signature. So now, if this is maintained during course of your transaction, and all the details are supposed to be mentioned about the stock, and in fact it is also mentioned therein that in so far as July month is concerned, the stock that was available with you, and you yourself has mentioned that transaction during the month is nil, then where is those materials?
My lord, the Exhibit 10, this there's the in the place where the taken over has been written. My lord, if you see, there is a score. There is a scoring of a signature. There is a scoring of a signature just before or above the taken over part. In Exhibit 10, that is page 33 for the month of July.
No, scoring is there, but below the scoring, the signature which is there, it appears clearly. It is also of you. This VB Das signature that was there, and you have just somebody has scored it out. Let us say that, but somebody has scored out. There are 3 signatures on that page which belong to you. One has been scored out, the other 2 are available, and those have been marked as exhibit also. One is marked as exhibit 10/4, in which handed over it is written, and in taken over, your signature is there. Date is same. Date is same, 23/7/92. Okay, and this when this person left it, Mr.
Well, sir, 22/7/92.
22/7. My lord, your lordship can have a glance over FIR, my lord. FIR says on receipt of the information that 4 quintal 3 kg of iron rod worth of rupees 5,000 has been misappropriated by Sri Bonabihari Das, JE Jaleswar Irrigation Section 1, and enquiry was conducted. Enquiry reveals that 46 of paper book, my lord, page 46.
Yeah, read out.
Enquiry reveals that Sri Bonabihari Das, JE, while posted to Jaleswar Irrigation Section number 1, had received the following quantities of steel and iron rod from Sri BC De, contractor, on I'll harp on the date, your lordship. 2/12/89. It is not 23/7/92, my lord. That is the entrustment date. That is 10 mm diameter steel, so and so, 8 mm diameter MS rod of 0.025 kg, 16 mm diameter MS rod 0.94 kg, 22 mm MS rod 2.26 kg, which comes around 4 quintal 3 kgs on total. Site account register for, for the work creek irrigation through Chitai and Gosala Nala in Bhogarai block disclosed that Sri B.B. Das JE has received the above steel and iron rods on 2/12/89. He had not issued the same for any construction work from the date of receipt till 23/7/92. The same has not been proved anywhere in the by the prosecution. Ki se 2/12 re entrustment seta BC deyithile and he has not used or he has received or he has not used anywhere henceforth.
My lords, the fact remains that till 23/7/92 he was holding those stocks, my lords.
It is not proved.
Best judgment. This is that that part has been marked as exhibit 10/4, where he has received on the date, of course, is mentioned at 1/4/89, not 2/12/89. 2/12 कौन है इतना? 2/12/89 received. अच्छा, लिखा है received from so and so contractor. अच्छा. ये जो स्टॉकटा এটা 1989 ରୁ ରନିଂ କରୁଛି।
Yes.
ତା ଭିତରେ କୌଣସି ଆଉ ଟ୍ରାଞ୍ଜାକ୍ସନ
କାମ
ହେଇନି, କାମ କିଛି ହେଇନି।
ନାଇଁ।
ଯାହା ଏଇ ଯୋଉ ଅନ୍ୟାନ୍ୟ ଜିନିଷ ଗୁଡାକ ଦେଖା ହଉଛି, 4 ବ୍ୟାଗ ସିମେଣ୍ଟ ଇଏ ହେଲା, ଏଗୁଡା ସବୁ ଦେଖା ହଉଛି। So far as rod is concerned,
no transaction.
there is no transaction, and that continued till this July 1992, and suddenly in August 92, PW2 बोधे ताना से जो
The successor,
Anil
H. Kumar
Kumar
Panda.
successor, he had mentioned that OS nil, and he has further written that BS Das has not handed over the steel in charge paper, hence the transaction for the month is nil. What is the name of that?
Anil Kumar Panda, successor.
AK Panda लिखा है जी।
Mal.
25/8/92 रे अनिल पंडार एविडेंस रे केबे से जॉइन कला कोची
My lord, 23/7, 10, I guess. 10/7, 10/7/92, my lord.
ने आउथरा सुन PW2 एविडेंस अस
On 23/7/92, he took over the charge.
हां सही रे तो 10 टू के केमते ये पूरा 22 तारीख जाए
23 तारीख को ना ये ज्वाइन कर.
हां राइट I took over
Yes.
the I took over charge of my post from one Bono Bihari Das
Yes,
means
on
the appellant.
23/7/92.
23/7/92. This is our charge report. Charge report को प्रमाण है इसे. Taking over the original remains with the person who gives the charges. Another copy remains with the person who takes the charges. Other 2 copies remain with the consular. This is the charge report.
Yes.
SDO. This charge report bears my signature and signature of Bibida. Charge report is marked as Swansu. Signature on this last page marked as Swansu. Signature of Bibida is marked as Exhibit 9/2. At the time of handing over the charge, Bibidas did not hand over the charge of some articles which have been categorically mentioned
in the charge report.
In the charge report
At page
12, item number 1 of the balance amount of the side account was not handed over to Bibidas. The
To
said
me
page,
by Bibidas.
to me by Bibidas. The said entry of page number 12 is marked as exhibit 9/3. अच्छा देखिए तो 9/3 टा कौन अच्छी नहीं नहीं सीटा ये बाहर करो जोटा PW2 रो एविडेंस टा जोटा देख did not hand over the item at page number 12. Okay.
That page
item
entry,
number 1.
That entry of page 12 is marked as exhibit 9/3, which your lord
हाँ मार्क में देख सकले सही ये जो चार्टा जिन्स Mr. Rizvi, exhibit 9 रे सब जिनस जहाँ जहाँ ये चार्ज रे नहीं ची कि PW2 सब विषय उल्लेख अछि एवं तादर मध्य से लिखी जी टेकन ओवर करी सिग्नेचर मध्य देई ची डेट पकई ची 23/7/92 तो এই जो पर्टिकुलर आइटम टा करछि एटा होछि कार्बन कॉपी रे ये छि हला
yes madam
तापरे आरो से जो सिग्नेचर एटा रे से नील नील केमती लिखिला तले चार्ज तो नेला बेली लिखुछि टेकन ओवर लिखिला तापरे नील केमती अन्य पेन रे लिखिला इसे कार्बन येटा have you seen this page
no
please see it the password धीरे कार्बन कॉपी रे ओरिजिनल ये केमती आसीओ से निजे कहूची जे ओरिजिनल टा नहीं गला किए जो लोक चार्ज देइथला मो पाखरे अपलेंट नहीं गला मो पाखरे रहिला कार्बन कॉपी आ गोटे कार्बन कॉपी रहिला गला ताले जदी मने करंतु से वेरिफिकेशन बेले एई आइटम गुडा को नेला नाही ताले सेठी लिखिवा कथा नॉट रिसीव्ड ताले एटा भी कार्बन पेपर रे सिया लिखा है दादा तेणु हुए तो ये जो नील नील लिखी आरो जो
Original.
appellant पाखरे जो original टा रहिला ता देहरे हुए तो एथि नील नथिबो.
My lord, the original is Exhibit C.
Exhibit
C.
See,
exhibit C टा देखिले
नहीं ता धरे.
नहीं ता माने केमती जा तबरे आपण पछरे नील लिखि देबे ता कहबे मु नेइनी सेते बेले तो कहले सिग्नेचर देखंतु
My lord, he
लास्ट टू
has
सिग्नेचर देखंतु तार अछि ता पर पेज रे वाडू बस टेकन ओवर करी सिग्नेचर नेइछि सेटा कार्बन कॉपी रे लिखाई पूरा लास्ट पेज को पळे जान सभा तळे अछि सिग्नेचर
taken over.
टेकन ओवर सेही कार्बन ए जो सिग्नेचर रही तार
Signature
डेट
is,
डेट भी देइछि 23 साथ केते
that is in original
हां
blue point pen record.
हां ब्लू पॉइंट पेंट बट 23 साथ रो डेट टा
Again.
किंतु वर्तमान आपण सी गोटे आपण जोटा प्रमाण करूचंदी
Again.
सी भी सेटा प्रमाण करूचंदी दैट इज एग्जिबिट सी एग्जिबिट सी देखो जे ए राइटिंग गुडा ता धरे नाही इट दिस दैट इज योर सब्जेक्ट ताले
My lord, he has admitted in the cross examination कि से निजे लिखी चंदी.
हां
PW2 has admitted in the cross
हां no
examination.
that is appears also
हाँ,
that
कि
he
से
has
निजे
written.
सेटा original ball point pen रे लिखी चंदी.
तो जो कार्बन कॉपी प्रिपेयर हला ओरिजिनल हला तार कार्बन कॉपी प्रिपेयर हला से ओरिजिनल ले आपण लिखिले आपण चार्ज नहीं गले तापर आपण पाखे जो कार्बन पेपर रहिला ता धीरे आपण जहाटा इंसर्ट करिवे जोटा कि ओरिजिनल ले नथिबो कैन ऑन दैट बेसिस विल से दैट यू हैव नॉट बीन हैंडेड ओवर द चार्ज ऑफ दिस सेति बेले लिख दवार कथा जे गुडा को मते दिया हिनी बोली मुआर चार्ज नहीं. So it is a subsequent thing which has been mentioned therein. से जो डेट फेट पकाई जो जहाँ भी हेची उडा सबु परे हेची माने अन्य पेन रे स्वतंत्र जणा पड़ी जाउची दिस इज नॉट द कार्बन ये एग्जिबिट सी टा बाहर करंतु आन अपन एग्जिबिट सी रो सेही पेज दे दियो सी टा बाहर कर दे दो
But that apart, there are two other exhibits, two important documents I'm relying. Exhibit 4 and Exhibit 3. Exhibit 4 is the letter dated 4/12/97. Accused has written to the SDO stating therein that on 23/7/1992 he has surplus rods. Accused has written to the SDO concerned, my lords, by letter dated 4/12/97 that on 23/7/92 he has surplus rods. This is Exhibit 4. And there is another Exhibit 3, my lords. It's a letter dated
Exhibit 4 टा बाहर कर लो Rita.
Exhibit 4, my lords. 3 and 4.
Exhibit 4 Lakaichi, I beg to report that I received your above letter on so and so. Came to know that as per the report of so and so, you have intimated me that I have not handed over the steel materials so and so at the time of handing over the charge. As per your letter, the mentioned steel materials have already been handed over. लिखिछन्ति परा on 23/7/92 23/7/92 at the time of handing over the charge and taking over the charge, and this thing has also been clearly mentioned in the copy of the charge paper in which myself and Sri Ponda JE are signatories. I submit the Xerox copy of the charge paper, page number 12, only for your kind perusal, and humbly pray that I may not be harassed further without proper query in this regard, because the alleged steel materials are lying in the section office, which may be verified by you. This is my report with so and so. So, ये चिट्ठी exhibit 4 रे यहाँ ही लिखा है जे आज्ञा मते मु ताऊ चार्ज रे देइची से डॉक्यूमेंट से स्टील रोड गुडा को से या ऊपर पड़ीथला जो
Site officer.
हाँ of harass one so lying at the section office. So maybe that ପରେ ये ନିଜେ misappropriation କରିକିନି ଲେଖି ଦଉଛି nil 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 କାରଣ ଆମେ ଜିନିଷଟା ହଉଛି ଯେ ଚାର୍ଜ ହ୍ୟାଣ୍ଡଓଭର ଯୋଉ ପେପର୍ସ ଅଛି ତା ଦେହରେ ଅରିଜିନାଲ ରେ ମେନସନ ହେଇଛି ଯେ ଚାର୍ଜ ହ୍ୟାଣ୍ଡଓଭର ହେଲା ଏବଂ ଏ ଜିନିଷ ଗୁଡାକ ଦିଆ ହେଲା ଏବଂ ତାକୁ ସିଏ ଦସ୍ତଖତ କରିକି ରଖିଛି ଯୋଉଟା କି ତାଙ୍କ ତରଫରୁ ଏଟା ପାଇଲେ ଏକ୍ଜିବିଟ ସି ଟା କଣ ଗୋଟା ଆଣ ଇଆଡେ
Last thing.
ଜଜମେଣ୍ଟ ପରେ କୋଉଠି ଏକ୍ଜିବିଟ ଆସିବ ହଁ ये जो एग्जिबिट सी टा किए मार्क करेला
My lord, DW2, the accused.
एटा
DW1 and DW2.
पेज नंबर 12 ना
Admittedly, the original copy was.
एटा तीन देखाम दो रिजवी बारह नंबर पेज रे सब गुड़ाक चार्ज नहीं देखो दस्तखत कर निजे तार गोटे कार्बन कॉपी रिटर्न कला कार्बन कॉपी रे लिखिदेला नाई 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 नील 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 अरे ओरिजिनल लिखुछु मु पाइली बेली कार्बन कॉपी रे केमती
नील लिखि देछि
तेणु बर्तमान से खाता भी यदि धरा जाए खाता रे एतिकी ताकू दिया हितला सी मानुची मते थिला एवं हाँ एवं ताकू हैंडओवर जदि हैंडओवर कर दिया गला तले आरो रोल केमती आसीबो ये कोन मिसअप्रोप्रिएशन कला प्रिवेंशन ऑफ करप्शन एक्ट देखी जजमेंट है that's not the judgment so it lower court judgment है 13(1) सीट आउची
if he dishonestly
or fraudulently misappropriates or otherwise converts for his own use.
So it is linked to that again that word appears that misappropriation is to be proved.
Yes.
And it is also to be proved that he has otherwise converted to the own use and he is a public servant, then all these offenses be almost identical thing. It's not that it is different. So once that goes means this will also go. S.N. Mishra is a good judicial officer. How he put such type of questions, 161 statements.
My lord, I've given the note of submission and the citations.
$409 ଉପରେ କିଛି decision ଦେଇଛନ୍ତି?
Interest.
ଇଣ୍ଟରେଷ୍ଟମେଣ୍ଟ କାହିଁ କୋଉ decision ସେଗୁଡାକ ସେତିକି ମତେ ବାହାର କରିଦିଅନ୍ତୁ ଆଉ ବାକି ଦରକାର ନାହିଁ ଏଇଟା
Yes, I am also referring to one decision of your lordship's kind perusal. Kindly come to para 6 matters. I've just flagged it, my lords. Page 185, para 6. That's the last 8th line, my lords. The sentence starts with the principal ingredient. Para 6, the last part, my lords. The principal ingredient. May I just place it, my lords? The principal ingredient of the offense being dishonest misappropriation or conversion, which may not ordinarily be a matter of direct proof, entrustment or property, and failure in breach of an obligation to account for the property entrusted, if proved, may in the light of other circumstances justifiably lead to an inference of dishonest misappropriation or conversion. Conviction of a person for the offense of criminal breach of trust may not in all cases be founded merely on his failure to account for the property entrusted to him or over which he has dominion, even when a duty to account is imposed upon him, but where he is unable to account or renders an explanation for his failure to account, which is untrue, an inference of misappropriation with dishonest intent may readily be made.
No, here the very letter which you refer to, that shows that he has explained it. He says that I have already handed over to Mr. PW2.
Yes.
And here this is the charge here, so don't harass me further. But prosecution, the original that charge handover, that was not relied upon. It was a carbon copy which was available with the accused,
yes,
in which subsequent writings were there. That was relied upon to convict the
Exhibit
accused.
9 instead of Exhibit C.
Right. Exhibit C is the original. You are not giving any importance to the original. You are giving importance to a carbon copy in which tampering has been made. So, Lekondu.
And no questions were also put regarding Exhibit C to PW 1, 2, 9 or 10, my lords. And all
no,
through the trial.
Exhibit C, obviously, question could not have been proved because they proved it at the defense stage. Okay.
Yes.
The appellant, Banobihari Das, faced trial in the court of Learned Special Judge Vigilance, Baleshwar in TR number 261 of 2007 for offences punishable under section 13(2) reduced section 13(1)(c) of the Prevention of Corruption Act 1988 on the accusation that he being a public servant functioning as junior engineer, Jaleswar Irrigation Subdivision attached to Section 1 from 1810-1987 to 22/7/1992, received mesh rod of different sizes with 4 quintal 3 kg from the contractor K.C. Roy. K.C. Roy तो था ना?
BC दे मैडम
चार्ज होची केसी रॉय
अच्छा
prosecution does not know.
K.C. Roy, contractor K.C. Roy, and on inventory on 17/2/1995, a shortage of the MS rod came to 3 quintal 73 kg worth of rupees 5,000, which has been dishonestly and fraudulently misappropriated or otherwise converted to his own use entrusted upon him or under his control as such public servant. Stop. The appellant was further charged under section 409 of the Indian Penal Code on the accusation that he being the public servant and entrusted with MS rod of different size weighing 4 quintal 3 kg during the aforesaid period committed criminal breach of trust in respect of the said property worth of rupees 5,000. That is iron rods of different sizes. Stop. The London Trial Court by judgment and order dated 19/11/2010 has been pleased to hold the appellant guilty of both the charges and sentenced him to undergo rigorous imprisonment for 2 years on each count and for the offences under section 13(2) reduced section 13(1)(c) of the Prevention of Corruption Act 88 and section 409 of the Indian Penal Code, and he was further directed to pay a fine of rupees 5,000 in default to undergo further simple imprisonment for a term of 4 months. Both the substantive sentences were directed to run concurrently. The prosecution case, as per the first information report lodged by Karthik Chandra Biswal,
PW9.
bracketed
PW9.
PW9, before the Superintendent of Police Vigilance, Balaswar, is that he received information about misappropriation of 4 quintal 3 kg of iron rod worth of rupees 5,000 by the appellant, and accordingly conducted an inquiry. And the inquiry revealed that the appellant, while posted as Jaleswar Irrigation Section 1, received the steel and iron rods from one BC Day contractor on 2/12/1989. And those rods are 10 mm dia steel, quintal 0.58 kg, Roman 2, 8 mm dia MS rod, quintal 0.25 kg, number 3, 16 mm dia MS rod, quintal 0.94 kg, 4 IV, 22 mm dia MS rod, quintal 2.25 kg,
26
kg, and the total comes to 4 quintal, अच्छा quintal 4 करिए 03 kg लग दिया. It is the further prosecution case as per the FIR that the aforesaid quantity of rod was received by the appellant on 2/12/1989. And till 23/7/1992, he had not issued the same for any construction work from the date of receipt. On 23/7/1992, the appellant handed over the complete charge of Jaleswar Irrigation Section 1 to Sri A.K. Panda, bracketary PW2, J. And however, the steel and MS iron rod were not handed over to PW2. And therefore, the appellant, being a public servant, committed criminal misconduct of dishonestly misappropriating 4 quintal 3 kg of steel oblique MS iron rod worth of about 5,000, abusing his official position. PW10 Apurva Kumar As was the OIC of Vigilance Police Station. As per the direction of SP Vigilance, Baleswar, registered the case and handed over the charge of investigation to Sri K.C. Biswal, Karthik Chandra Biswal, bracketary PW9 for investigation. PW9 after taking over the charge of investigation, examined the witnesses, seized certain documents, prepared the seizure list, Exhibit 17, and visited the spot on 39/1994 and handed over the charge of investigation to Sri A.K. Nath. A.K. Asala Apurva Kumar As, brackets PW 10. After taking over the charge of investigation again, PW 10 submitted requisition to the Executive Engineer Irrigation Division Baleswar and SDO Irrigation Subdivision Jaleswar about the charge papers between the appellant and PW2. And on 2/1/1995, he seized certain documents, namely copies of the charge paper in between the two, and later number 16 of Executive Engineer Irrigation Division Baleswar and prepared seizure list by Exhibit 16. The charge papers bear the signatures in original of both the appellant as well as PW2. And it was found out that on 23/7/1992, the appellant had handed over the charge to PW2. The PW10.
PW. My lord, appellant handed over the charge to PW2.
Right, PW2. Handed over charge of investigation, charge to PW2. And from the letter of the Executive Engineer Irrigation Division, Baleswar, the valuation of different iron rods were furnished, and which is and the same is marked as Exhibit 11. Exhibit 10 is the register in which the appellant had mentioned the amount of rods which he had received from the department. And page 32 and 33 in the said register marked as Exhibit 10, it revealed that the appellant handed over the charge of excess rod to himself on 23/7/1992. The IO examined the witnesses, conducted inventory of the office room of PW2, during inventory of iron rods of different sizes were found inside the storeroom. And accordingly, the inventory report was prepared mentioning the quantity, value, and sizes of the iron rod. And the said inventory report is marked as Exhibit 5. Exhibit 5 टी दिखाएं जाएंगे. The iron rods found inside the storeroom were seized and a seizure list was prepared. And the IO left the rods in the Jima of Kashinath Mishra, bracketed PW1, assistant engineer of Jaleswar Irrigation Subdivision. On due examination of a Jimanava by him. The original letter of the SDO Irrigation Subdivision Jaleswar and the original explanation of the appellant pursuant to such letter were also seized as per seizure list Exhibit 5. And some other letters were also seized from the office of SDO Irrigation Subdivision Jaleswar on 22/4/1995.
Our seizure list is marked as Exhibit 8.
Which is
Seizure list, it will be Exhibit 8 instead
But
of 5.
Exhibit 5 is the inventory.
Exhibit 5 is a different document.
it is the Exhibit 8.
Yes.
Seize the তারপরে এই যে লেটার্সটা হচ্ছে 5 লেটার্সটা সেটা হচ্ছে Exhibit 18 is the seizure list না. He also seized 4 letters from the office of Executive Engineer Baleswar Irrigation Division and prepared the seizure list marked as Exhibit 21. The contractor who executed the construction work of Guanala Irrigation Creek at village Kharidchak was also examined, and he is Vrindavan Chandra De.
Not examined.
No.
Examined by the IO.
The investigating officer, as per the direction of SP Vigilance, made the Chief Engineer Irrigation to obtain sanction for prosecution against the appellant, and he discussed the facts of the case, produced all relevant documents and documents of the case for his perusal, and on 19/1/1996 he received the sanction order through SP Vigilance Baleswar, which is marked as Exhibit 22. The appellant was arrested and he was released on bail. On completion of investigation, PW 10 submitted charge sheet against the appellant for commission of offences under Section 13(2) reduced Section 13(1)(c)(d) of the PC Act and Section 409 of the Indian Penal Code, on the accusation that the appellant as the JE had misappropriated a sum of rupees 4,525 towards the cost of the iron rods. What is the date of handing over the charge?
23/7/92.
All right. The appellant while not disputing that he received the surplus oblique unutilized MS rod of 4.03 quintal of different sizes from contractor Vrindavan Chandra De in his accused statement to question number 3 stated that he had handed over the charge of investigation, a charge of the iron rods to PW2. It is a specific stand in the defense plea that he has not misappropriated any rod and he has been falsely implicated in the case. The London trial court, after assessing the oral as well as documentary evidence on record, has been pleased to hold that on 23/7/1992, the appellant handed over the charge to his successor, bracketed PW2, It was further held that the prosecution has established that the accused had with him the surplus iron rods on the day he handed over the charge to his successor, bracketed PW2, but he, having taken a plea that he had handed over the said rod to his successor, It was further held that Exhibit C has to be discarded as it doesn't reveal that the surplus iron rods were handed over to the by the appellant to PW2. It was held that the appellant did not hand over the iron rods in question to PW2 on 23/7/1992 at the time of handing over the charge. It was held that the materials available on record and the false defense of the appellant cumulatively established that he criminally misappropriated quintal 4.03 kg of iron rod received by him after conclusion of the work in question. The learned trial court further held that non-examination of the sanctioning authority is not fatal to the prosecution, and there was a valid sanction for prosecution of the appellant. And in the ultimate analysis, it was held that the prosecution has succeeded in establishing the guilt of the appellant for both the offenses, both the charges. Your name is there in the...
No, I did not given the name. Tejasmita Mahapatra.
Tejasmita Mahapatra, Land Counsel, appearing for the appellant, challenging the impugned judgment, contended that though it is the prosecution case that the appellant received the iron rods in question from one
Vrindavan Charan De.
Vrindavan Charan De. But in the charge, it has been mentioned that he received the same from one K.C. Roy. Neither K.C. Roy nor Vrindavan Chandra De have been examined during trial to substantiate that they handed over 4 quintal 3 kg of MS rods of different sizes to the appellant. The Land Council further argued that a question has been put by the Lenin trial court in the accused statement that it transferred from the evidence of PW2 that the appellant had received surplus unutilized 4.03 quintals of MS rods of different sizes from contractor Vrindavan Chandra De to which the appellant answered that yes, he had taken, he answered in affirmative. But nowhere PW2 had stated about the said aspect in his evidence. Therefore, the London trial court should not have put such question in the accused statement. It was further argued that in question number 14, it was put to the appellant that from the evidence of PW10, the IO, it revealed that during his investigation, he had examined the contractor Brindavan Chandra De, and the said contractor had stated before him that he had returned the excess iron rods after completion of the construction work to the appellant. Since Brindavan Chandra De contractor has not been examined, the London trial court was not justified in putting the 161 CRPC statement of Brindavan Chandra De alleged to have been recorded by PW10 in the accused statement to the appellant. It is contended that since the London trial court has committed illegality in putting questions like question number 3 and question number 14, the answers given by the appellant cannot be utilized against him and should be taken out of consideration. The Land Council submits that in absence of any examination of the relevant witnesses like BC De or KC De, KC Roy, from which the appellant stated to have received MS rod of different sizes, the entrustment part cannot be proved, cannot be established. And even if in the stated that the petition, that the appellant was having in possession of the MS rods of different sizes of quintal 4.03 kg, 4 quintal 03. But Exhibit C, which is the original charge handing over document, would reveal that same has been handed over to PW2. And the London trial court, without relying on the original document, has relied upon a carbon copy of the same in which tampering has been made by PW2, mentioning not to have received the iron rods. The Land Council submits that once the original document by Exhibit C has been is taken into account, and it shows that the iron rods were MS rods, iron rods were handed over to PW2. The question of misappropriation doesn't arise. In fact, it would be the responsibility of PW2 to explain as to what he did with the iron rod. The Land Council further submits that there is every possibility that after receiving the iron rods from the appellant, the PW2 has misappropriated the same and manipulated some documents, and in order to save his own scheme, foisted a case against the appellant. And therefore, it's a fit case where benefit of doubt should be extended in favor of the appellant. Mr. M.S. Rizvi, the Land Council, that when in the accused statement, the appellant has specifically admitted to have received the surplus oblique unutilized MS rods of 4.03 quintals from contractor Brundavan Chandra De, non-examination of the contractor cannot be a factor to disbelieve the prosecution case. The Land Council further argued that the documentary evidence, like what is that entity जो खाताड़ा कहते हैं?
Exhibit 9 में charge rate.
No,
Exhibit 10 is the site account registration.
Exhibit 10 reveals that as on the date the petitioner handed over the charge of investigation for the month of July 1992, he was having the stock of 4 quintal 3 kg of rod, and in that month there was no transaction, and therefore he should have handed over the entire iron rods to his successor, who is none else than PW2.
My lord.
But the PW2 has mentioned in Exhibit 10 that while handing over the charge, the appellant had not handed over the iron rods. And
my lord, may I be excused? Your lordship has dictated handing of taking of the charge of investigation.
No, I'll correct it first. Therefore, the London trial court was justified in relying on Exhibit 9, in which it is specifically mentioned that that PW2 has not taken over the charges of the iron rods mentioned in page 12 of Exhibit 12. The
page 12 of Exhibit 9.
Exhibit 12, Exhibit 9. The Land Council submitted that the London trial court has rightly taken into account the evidence on record, so also the documents proved on behalf of the prosecution, to arrive at the conclusion that the appellant was entrusted with 4 quintal and 3 kg of rods, and he has misappropriated the same, and therefore the charges have been duly proved. Therefore, the appeal being devoid of merit should be dismissed.
Let's further, no questions were put regarding Exhibit C also. Exhibit C, no questions were put to PW 1 to 9, 10. But no questions were put with regard to Exhibit C, madams.
No, who has proved that Exhibit C?
That is that original charge.
My lord, DW 1 and 2.
Who has proved it?
DW 2, madams. The accused.
No.
DW, my lord.
You are telling Exhibit C.
Yes.
Exhibit C has been proved by whom?
They say that is the original charge report, madams.
No, who has proved? Mr. Rijvi, who has proved Exhibit C? It is proved at the defense stage.
Yes,
So
DW2.
where the accused statement is to be made on the basis of the prosecution evidence. It's not the defense evidence. Look, adverting to the contentions raised by the learned counsel for the respective parties, 8 दियो से CRPC टा दियो जो 409 जो तरह से मोटा वोटा IPC CRPC In order to prove a case under section 409 of the Indian Penal Code, it must be established that the accused was a public servant, Roman 2, that he was entrusted in such capacity with property, Roman 3, that he has committed breach of trust in respect of such property. Once entrustment is proved, it is for the accused to prove how the property entrusted was dealt with. I pitched a good one. Criminal breach of trust has been defined under Section 405 of the Indian Penal Code. In order to prove the same, there must be an entrustment, there must be misappropriation or conversion to one's own use or use in violation of any legal direction or of any legal contract, and the misappropriation or conversion or disposal must be with dishonest intention. Where the entrustment is missing, the same would not constitute a criminal breach of trust. In the case in hand, PCR করাও ধীরে 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 Section 13(1)(c) of the PC Act also states that if a public servant dishonestly or fraudulently misappropriates or otherwise converts for his own use any property entrusted to him or under his control as a public servant, or allows any other person to do so, then he can be said to have committed offense of criminal misconduct, which is punishable under Section 13(2) of the PC Act. In the case in hand, the prosecution case at the threshold when the first information report was lodged was that 4 quintal 3 kg of steel and iron rods were received by the appellant from contractor BC Day on 2/12/1989. However, in the charge, it is mentioned that the MS rod of different sizes weighing 4 quintal 3 kg were received by the appellant from contractor K.C. Roy. It cannot be lost sight of the fact that the first information report was lodged after receipt of information and conducting inquiry. Therefore, there is inconsistency as to from which contractor the appellant received the iron rods in question, steel and iron rods in question. Neither any of those contractors have been examined during trial to substantiate the same, nor any documentary evidence was proved on behalf of the prosecution that on 2/12/89, steel and iron rods were received either from BC Day or from K.C. Roy. The London Trial Court has put the following question as question number 3. Quote the question, and the answer given by the appellant was in affirmative. After going minutely through the evidence of PW2, the London Council, Additional Standing Counsel for the Vigilance Department, Mr. Rizvi, fairly submitted that nowhere PW2 has stated that the appellant received surplus unutilized 4.03 quintals of MS rod of different sizes from contractor Brindavan Chandra De. I have also gone minutely through the evidence of PW2 and found that there is nothing in his statement in that respect. Similarly, question number 14, which was put to the appellant in the accused statement, it reads as follows. Quote first question number 14. This question, the answer to this question has been given in affirmative, but it seems that this question is based on 161 CRPC statement of contractor Brindavan Chandra De before the investigating officer. Law is well settled that statement recorded under section 161 CRPC is a substantive piece of evidence, and it can only be used for use of contradiction and corroboration to the evidence of a witness who is examined in court, when examined in court. Number Code of Criminal Procedure. Section 300 CRPC requires that the attention of the accused must specifically be brought to the inculpatory pieces of evidence to give an opportunity to offer an explanation if he chooses to do. Circumstances which are not put to the accused in his statement under section 313 CRPC cannot be used against him and have to be excluded from consideration. The examination of the accused under section 313 CRPC is not a mere formality, the questions put and the answers given have great use. It is a direct dialogue between the court and the accused. The material evidence against the accused should be brought to his notice in order to enable him to give explanation. When there is no evidence or there is no circumstance appearing in the evidence against the accused, there is nothing for him to explain, and no question need consequently be put to him. In the case in hand, when the evidence of PW2 is silent that the appellant had received surplus unutilized 4 quintal 3 kg MS rod of different sizes from contractor Vrindavan Chandra De, the Lenin trial court should not have put such question to the appellant in the accused statement. As there was no evidence, by putting such question, the Lenin trial court has committed illegality, and therefore answers, if any given, has no relevance and cannot be utilized against the appellant. Coming to the question number 14, as pointed out by the Lenin counsel for the appellant, it reveals that this question was formulated on the basis of 161 CRPC statement of contractor Vrindavan Chandra De, recorded by PW10, and in that statement the contractor allegedly stated that he had returned excess iron rods after completion of the construction work to the appellant. चार्जशीट देंगे रिसर्च ये केस डायरी नो LCR টা হতো হ্যাঁ এইটা দিয়ে দিই LCR দিয়ে Vrindavan Chandra De has been cited as charge sheet witness number 14, but for the best reason known to the prosecution, he has not been examined during trial. A statement made by a witness to a police officer during course of investigation recorded under section 161 of the code is not and cannot be treated as substantive evidence. It may be used for the purpose of contradicting the evidence of the prosecution witness, and by confronting it in the manner provided under section 145 of the Evidence Act. Therefore, when being a charge sheet witness, the prosecution has not examined Vrindavan Chandra De whatever allegedly he has stated before the investigating officer, bracket PW10, a question should not have been put to the appellant under section 313 CRPC. The London Trial Court has committed illegality in putting such question, and therefore the answer given, if any, to such question is taken out of consideration. There is no dispute that the exhibit list over. The site account register has been marked as Exhibit 10, and for the month of July 1992, it was mentioned that there was availability of stock of 4 quintal 3 kg of iron rod of different sizes, steel and MS rod of different sizes. And during that month, the transaction was nil. But the appellant specifically pleaded that while handing over the charge to PW2, he handed over such rods which would be evident from Exhibit C, the original of the charge handover document, in which PW2 has put his signature and received different articles, including the steel and iron rods in questions, steel and MS rods in questions. From the side of the prosecution, Exhibit 9 was proved, which is the carbon copy of the charge paper. And PW2 has stated that at the time of handing and taking over charge, 4 carbon copies are prepared of the charge report. The original remains with the person who gives the charges, another copy remains with the person who takes the charges, and other 2 copies remain with the concerned authority. And the charge report, which has been proved to be Exhibit 9, by the prosecution, in page number 12, contains the original writings against the steel and MS rod to be nil, which were not there in the original charge report, which has been proved on behalf of the defense. DW1 Swapneswar Jana has stated that on 23/7/1992, the appellant was relieved by his successor, PW2, and the charge was handed over to PW2, and he was present at that point of time, and the charge papers were scribed by PW2, and the appellant was showing articles charge of which he was handing over to PW2. And he, along with the staff, were bringing the documents as per the version of the appellant. And after scribing the charge papers, the appellant and PW2 put their signatures in respective columns on each page. And accordingly, he proved the document marked as Exhibit C. When in the original charge report marked as Exhibit C on behalf of the defense, it is reflected that PW2 has received the steel and MS rods in question from the appellant on 23/7/1992. And Exhibit 9, the carbon copy, in the carbon copy, there has been incorporation, there has been tampering, comma, and it was mentioned not handed over, comma. The London trial court was not justified in acting upon a carbon copy of the charge report where there is tampering and not relying on the original charge report, which is proved by by the defense as Exhibit C. If on 23/7/1992, the steel and iron rods were available in the stock and the same was handed over by the appellant to PW2 and the charge report was prepared, it cannot be said that the appellant misappropriated the same. Once PW2 had taken over the charges, it is he who is to explain as to how the same was not found in the stock. There is possibility of PW2 himself misappropriating the rods in question and by manipulating the charge report Exhibit 9 in his own hand has foisted the case against the appellant. in view of the foregoing discussions, when there is no clear evidence regarding entrustment of the iron rods and steel, MS rod and steel rods in question, and the material witnesses have been withheld by the prosecution, and when tampering with the charge report has been made, and on the basis of original charge report, it appears that the rods were handed over to PW2, in my humble view, the ingredients of the offense, either under section 409 of the Indian Penal Code or 131C of the Prevention of Corruption Act, which is punishable under section 13(2) of the said act, are made out against the appellant, are not made out against the appellant. I'm of the humble view, are not made out. Are not made out. Therefore, the impugned judgment and order of conviction of the appellant is not sustainable in the eye of law. The appellant is acquitted of the charges under section so and so. The appellant is on bail, his bail bond stand, he's discharged from the liability of his bail bond. The surety bond stands cancelled. Put a note of appreciation on the effort of Ms. Mahapatra. Okay.
Obliged, madam.